Yes.
Your lordship sign for it. There is serial number 53. A personal problem, my lord. Something if we have translated also. Kindly grant me 2 weeks time, my lord.
At the request of learned counsel for the appellant, stand over to July, it will go to July, 9th July,
Sorry. End of this month, maybe.
end of the month. 26th July, June.
Lord, serial number 27. Please. For a week. Serial number 27.
Yes.
Lord, a matter for after notice was adjourned on 7th November, my lord. Thereafter, it's not listed. At the instance of the respondent accused, my lord, it was adjourned. So I want the matter to be listed, my lord.
What is the matter?
Contempt matter. It's a contempt matter.
After 2 weeks?
Please. My lord, may I make a mention, my lord?
With my lordship's kind permission. Serial number 24. I am appearing for respondent number 1. I request a week's accommodation. I have informed the Petitioner Council as well. That is present. Requested to be taken.
Delay of 13 days.
Yes.
So it is, notice is already issued in delay? Mr. So when shall we keep?
Next week.
It will go to July now,
Please.
4th July.
May I make a mention, my lord, regarding posting?
Other side, for a respondent.
Pardon?
Inform the respondent in serial number 27.
27.
For a week.
What do you want time?
Next week.
Next week will not be possible. We go in July now, 8th July.
Lord,
Serial number 8, my lord.
Yes.
Lord,
1 week. I have also filed
Yes,
a writ
Mr.
Lord, memo for posting, Lord, the BMRCL, respondent BMRCL, Lord, seeks permission of this honorable court to, Lord, implement the OM issued by the Deputy Conservator of Forest to, Lord, remove the trees standing, Lord, in the line of, Lord, the construction of metro, Lord. There is an urgency in the matter. Lord. Next week, any day, Lord. This week or next week.
It will be listed, Mr.
Lord,
The file is listed. This PIL.
PIL, Lord.
It will be listed.
It's only, Lord, consideration of, Lord, the OM, Lord, the, Lord, formal, Lord, order needs to be, Lord, taken by, Lord, the BMRCL to implement, Lord, the OM issued by the Deputy
If
Conservator.
we
of
grant
Forest.
you the listing, it will be later than normal listing. What do you want? Normal listing may happen within 1 week.
Yes.
If the court grants time to list the matter, it will be after 2 weeks. What do you want?
Normal list.
Normal list.
my lord, may I make a mention, my lord?
Yes.
Serial number 8, my lord.
Yes, 8. What do you
8. Respondent number 3 also filed a writ appeal, my lord. It may be connected with, clubbed with.
Let it be called out. Why it is?
Yes. Yes.
Once it is called out, we'll grant time. Yes, Mr. Yes, yes.
Lord, one request, my lord, regarding PIL, my lord, road widening. My lord, in Raichur district, once it was made, they have withdrawn. Second time also, my lord, third time. About 360 buildings are in problem, my lord. They are on the, my lord, keeping that machines and everything were in difficulties. During this week or next Monday at least, can I?
What is the subject matter?
Subject matter is, my lord, land, my lord, the road widening by, my lord, National Highways Authority. It was dropped already, politically based, my lord, everything. Next Monday, can I expect, my lord? I will be able to convince, my lord. Totally, my lord, the 360 buildings
you have
are
to
in
convince
problem.
about early listing. Then
My lord, hospitals, schools are in problem. Therefore, next Monday, can I expect?
After 2 weeks.
Can I expect a date? Otherwise, it will not be listed. At least a date, my lord, on 10th next Monday. I will be able to convince, my lord. Subject to your lordship says on that day, my lord, I will receive the order.
Who says that you will not be able to convince?
I only difficulties are. Otherwise, I would not, senior counsel, I would not have moved the matter. Next Monday, can I expect? At least 1 week, I think. Sorry, my lord. Extremely sorry, my lord.
We are also sorry. Not before 2 weeks. Yes.
At least a date on that day. Also.
Date will be given after 2 weeks. Given a date. Post on a date. Yes.
Serial number 18,
18. Yes. What do you want? Contempt. So.
The affidavit is
for respondent. Why do you want? In contempt, no senior is. No senior is necessary. Let it be called out. We'll see. You remain present. will not damage you in any manner whatsoever, except that asking you to remain present.
That serial number 25, 25, my lord.
Which one?
Serial number 25, my lord.
25.
My
yes.
lord, the council appearing on the appellants, my lord, is not feeling well, my lord. Kindly have it week after next, my lord. 25, my lord.
After 3 weeks.
My lord, interim order may kindly be extended. my lord. Interim order may kindly be extended.
It will be extended, yes.
My
Your
lord,
Honor.
serial number 37, I appear for respondent number 2, my lords. Minutes of meeting has been held, including all the stakeholders, my lord, petitioner and other respondents. Status report has to be filed. 2 weeks time may be given, my lords, to file.
2
status.
weeks.
Yes, my lord.
Other side is no objection?
My lord, I appear for the petitioner online, my lords. I have no
Yes.
objection on this.
All right. 2 weeks.
Any date may be fixed after 2 weeks.
After 2 weeks, some date will be given.
Please, grateful, my lords.
Yes.
Grateful, my lords.
Your Honor, may I make one submission? The appellant university has not complied with the office objections for the past 1 year. On last occasion also, your lordship has directed to post this matter after compliance of office objection. The appellant university has taken the interim order and they are relieving the guest lecturers who had sought for regular.
Why you are in a hurry?
They are relieving the guest lectures. ma'am.
Relieving.
Yeah,
All right. Next
it
Monday.
may
Next
kindly be
Monday.
posted. Yeah,
Next Monday, 10th.
obliged, Your Honor.
It is 10th. This 10th.
That's item number 14. The complainant, if your lordships recollect, the children were allowed to spend time during the vacation with the father. However, now the complainant has approached the apex court in SLP so and so, and they have obtained a status quo order. So the children are still with the father. So it is actually, will be listed tomorrow. May I request for a date on 10th, my lords?
Lordship, the thing is, the application listed tomorrow.
So against our last order, this is help.
Yes, they have gone,
So
approached the
So any orders are passed by the Supreme?
There is a status quo order which my client has been served a notice, and the matter has been moved for vacation of status quo, which has been listed tomorrow. So may I request for 10th, my lords, next week?
Lordship,
there is one issue, Lordship, that the matter.
11th, madam.
My lords,
11th,
12th, my lords, not 11th. 11th, I have an
12th,
inconvenience.
12th.
12th, great.
I am also in this matter. I was in the Supreme Court. Lordship, what has happened is the Supreme Court had fixed the matter for the 11th of June. Now Lordship will have a look at the order, Lordship, so pleases. Yes.
However, it is moved and it is listed tomorrow.
Yes, ma'am. Now, Lordship, in this particular order, the matter was listed for the 11th of June. Now, what the other side has done is that they moved an application of vacation of stay, modification, clarification, and that has come up to be listed only for tomorrow. And what the Supreme Court causally says that only this IA for vacation of stay is to be listed, not the original matter.
That's exactly as
Now,
submitted
now the
also.
point is that is on the 11th of June or tomorrow, we know what date that will be.
Any which way
So,
your lordship
my
has
only
given
point now,
12.
Supreme
So
Court is in vacation right now. So Lordship may have it, if the matter, if whatever decision comes from the Supreme Court, the parties can make a mention.
Bound to be. That is what we
Request
are
the
also.
matter to be listed after, in the first week of July, Lordship.
why July?
I'll leave it
Your
to you.
lordship has.
I'll leave it to you, Lordship, because just in
But
case.
both
the
of we are saying that the Supreme Court is likely to take up.
The matter.
Will be bound by the
Lordship,
proceedings of the Supreme Court
absolutely,
and the order passed by the FS.
Lordship.
But since this is custody matter,
Yes.
we'll giving a date. We can adjourn if the Supreme Court is still considering.
Lordship.
We are not keeping it to press you to proceed with the matter.
And Lordship, in that case, Lordship may have it on,
For the
12th,
for the
12th is already fixed.
13th, Lordship.
12th, not 13th.
13th, my Lordship, I am before Lordship on
Third.
13th. 13th.
Grateful, my lords.
Yes.
My lord, serial number 22, my lord. Seek 1 week time, my lord.
Week time, 2 weeks. What, 1 second, what is 22?
Notice already. 22. Yes,
Wait, why do you want time?
22, my lord. Senior is
do-
not feeling well, my lord.
Hmm?
Senior is not feeling well, my lord. Kindly have 1
Senior
week,
is not well or not very well?
not feeling well.
Senior is not very well.
Yes,
May I make a mention, my lord? My lords, I had filed a writ petition challenging.
any date, ma'am?
When do you want this?
Next
This
week.
can go to 11th, 22.
My lord, this is actually an order against remand, my lord, that is filed by, passed by the learned single judge.
Therefore, I asked that with not well or not very well. No, Sent back to the tribunal. We are aware about it.
May I make a mention? Writ appeal for admission.
Which
my
one?
lord. Writ appeal
Ah,
for admission.
Hmm.
I have challenged the appointment of fifth respondent for the post of assistant professor. That has been dismissed by the Sambal court single judge
ah.
on the ground that this court has no jurisdiction. It has been, it has to be filed before the government. Therefore, I have challenged that jurisdiction question only before the Sambal court. They have initiated the that appointment order and dispersed the salaries to the respondent number 5, my lord. Kindly take urgency.
To argued the matter, what else? Why to list? It will
Kindly-
listed in due course, not by memo, yes. No urgency, yes.
My lords,
Yes,
I
ma'am.
may be permitted to make a mention.
Yes,
My lords, the present writ petition is filed against the tender issued by the Western Naval Command, my lords. In accordance with the fraud documents that were submitted by the unofficial respondents, the department is technically qualifying the unofficial respondent, my lords. It's completely upon the fraud and misrepresentation documents, my lords. It is also subject matter of the national security. In the last occasion, the matters was listed. However, it was posted to some other date because of the office objections. All of the office objections were complied, my lords. So I request my lords may kindly have it in the short date.
fresh matter,
Fresh matter, my lords.
after 3 weeks.
My lords, the urgency is this, my lords. They are qualifying the unofficial respondent, my lords, which causes a grave injury to the public expenditure.
But then if you remove the office objections, it will be listed.
It was already removed. We have already complied the office objections, my lords.
Then please don't mention, listed within 1 week.
My lord,
Date is already fixed, Mr. Counsel.
date
So-
has been fixed to 26th June, my lord. That is why we are moving a memo, my lord. On the last occasion when it was listed for non-compliance of office objection, it was
If
ordered
date
to be
is
listed
fixed,
on
we are not-
26th.
We will not change the date. Yes,
Your Honor, this is a contempt case and I'm appearing for the petitioner. There was a temporary injunction granted by the Honorable Single Judge in writ petition 4257 of 24. This is violated by the accused. This is for stay against further construction and has continued the construction and has completed constructing an additional complete floor. So this is causing hindrance to the adjacent hospitals and the general public. I
after
kindly
2, you want circulation,
request
posting
you
of the matter,
list the
after
matter
2
as
weeks, after some date after 2 weeks.
My lords, I mentioned, my lord. My lords, I had filed a writ petition challenging a circular issued by the Inspector General of Registration and Commissioner of Stamps. It was listed before the single judge, and during the course of hearing, my lord, the learned single judge directed the matter to be tagged along with the PIL, which has been listed today before my lords. My lords, however, my matter has not been tagged along with those with that PIL, my lord. Hence, I request my lord to take up my matter also along with that PIL. The PIL is listed at serial number 68, my lord.
When it is called out, we'll take.
I will make grateful, my lord.
Serial number 50, 1 week time. Serial number 50. A week time.
All office objections 3 weeks.
Serial number 1. Agent Prabhu Bharat.
Pray for petition, my lord. This contempt petition arises out of the Domestic Violence Act, my lordship, and accused is the son of the petitioner, my lordship.
Can you not execute that? You can execute this order. Before
No, my
the same,
lordship.
in the same court.
No, he's not obliging the same court, my lordship. He comes and he just disobeys the court order and he tries to get away. From the date of the order, only 5,000 rupees he has paid previously. Still date, not even executed a single pay, in spite of the order of the a single judge to deposit 50%. So he has not paid a single pay, my lordship.
We are not entertaining. The order which is brought under the contempt jurisdiction is an order is an order whereby when a single judge has only issued notice to the respondent, an interim order is passed on condition of the deposit of 50% of the arrears of maintenance. Full stop. in respect of the
least-
interim order where the,
At least direction may be given to the trial court for expedition of proceedings.
which trial court?
Magistrate court, my lordship.
Which
One-
magistrate?
First additional MMTC.
This order is passed by whom?
First MMTC, my lord.
Hmm?
Because keeping the order of the single judge is showing before the court that order is pending.
You are complaining of which order? Page?
My lord, page number,
Against the interim order, the contempt jurisdiction cannot be entertained since the rights of the parties are not finalized and the subject matter dispute is at large to be considered on merits. Full on a single judge. Therefore, the contempt petition is not entertained, leaving the complainant to approach the same court, which the court, which has passed the order to work out rights and remedies. This court does not express any opinion on the merits of the case of the complainant. Which order you are challenging?
order of the trial judgment.
Page.
Single judgment of High Court.
33? Yes. Disposed of according.
Seal number 2.
Here for the complaint.
Raghavendra G. Gayatri. Lord's case of non-release of retirement benefits. Lords. Case of non-release of retirement benefits. Impugned order at page 12, my lords. Direction is at page.
Learned single judge.
Division bench.
Order dated, the division bench of this court by order dated 28 August 23. Has directed while disposing of the writ appeal, comma.
Whereas
State
6
government
is
to
the.
consider the representative petitioner for release of the retirement benefits with applicable interest. Full stop. The bare perusal of the direction indicates that no time limit is fixed by the bench, by the court for the compliance. When there is no time limit is fixed, it cannot be said that by non-complying of the order, at this stage, any willful contempt is committed by any of the respondent authorities.
If I may make a submission.
However, at the same time, it would be right that the order of the court should not go uncomplied with. Full stop. In that view, the present contempt petition is disposed of by directing the competent authority respondent to comply with the direction by deciding the representation regarding release of the retirement benefit to the petitioner within a period of 12 weeks from today.
May I make a submission? It has been considered, in fact, not.
Already considered?
Already
It is not
considered.
yet considered, my lord. Just a communication is sent on last 30th, my lords.
If not so far considered, within 12 weeks from date of receipt of the order. Full stop. Before, in the beginning.
Lords, I have retired in the year 2013, my lords.
And learned government advocate, Mr. Mahindra, for the respondent authorities. Disposed of according.
Obliged.
So PL matter. Seal number 3. So Nagaraj NR. Finish, my lord.
This is a PIL now. Filed on behalf of the Akhila Karnataka Hindu Temple Police Archak Association, challenging the application of RTI Act on the temples of the state of Karnataka. Some of the people who are misusing the said act are practically harassing, torturing, and fleecing the archaks of the temples inside the in the Karnataka state. Religious charitable. Your Lordship might kindly see the section 2H. How enclosed at Lordship will get it. Annex C, my lord.
2H is what?
That RT Act I have.
Definition of public authority.
But yeah, public. The temples are not public authorities.
To go in individual case, generally it can't be approached like this in PIL. 2H is public authority, definition of public authority.
Temples are not public authority, hence RTI not is attracted. I'm.
Can't take that general view in respect of everything, every institution.
This is
every
covered
time.
by the authorities, my lord, of the Telangana High Court,
We'll keep it open you
I
to
should produce it.
raise grievance in the individual cases
I should produce it.
by contending that the Right to Information Act is not applicable
And our
because
own
this
High Court
temple is
also
not
has-
public authority. But generally, it can't be dealt with in such a way in public
They
interest.
are misusing it. They are misusing.
We do not know whether this temple is public authority, this temple is not. It depends upon the facts of the each
No,
case.
it's not one or two. There
We
are
can't take a general approach in this fashion in public interest.
Kindly peruse Telangana statement. Also, Bhavani case in the Kerala High Court. Then Bombay High Court at Goa. In regard to the and our own High Court in 2019 in Anjuman A Islam State, that's not both.
What do you say?
Lord, I have to seek instructions because admittedly, Lord, two honorable courts have passed the order.
No. Courts have, other high courts have passed the orders.
Lord, that is what is stated.
Like,
Lord,
pass
I do
over,
not-
Mr. Where
I
is
do
it?
not know if that is the same before the honorable Supreme Court, my Lord, that order.
So Supreme,
Verify.
Supreme Court has not touched it yet. Honorable Supreme Court has not touched this subject yet.
Not a general government is made with regard to the case, but nobody has come forward, my Lord.
Kindly peruse page number 109 and onwards. I have enclosed samples of the RTI applications for the kind perusal of this honorable court, my Lord. In fact, they are seeking such an information in preparing prasadams, how much sugar you are using, how much rice you are using, and how many archanas we would perform per day. These sort of the things. And all the materials are donated by the devotees only for their purpose. Government has not contributed even a single rupee for this.
Lord, where is the cause of action, my Lord? I can understand if some archak had come before my Lord saying that after getting this information under the RTI Act, he's been harassed. My Lord,
No,
general governments are made.
How?
A central act is sought to be restricted only to the state act.
Apply your mind on 11th we'll take. 11th of June. 11th of June. It doesn't appear to be case for anyway, 11th June.
This is number 4, writ appeal matters. Ajit Kalyan.
Here for the response.
Yes, what is rule 4?
Lords?
What is rule 4?
Lords, rule 4 speaks about the income levels and different grounds for consideration of compassionate ground.
Where is it? Read it.
So the rule is at page 50, my lords.
50.
And relevant rule 4 is at
Page 50.
50. 59 is rule 4, 59. It speaks about the conditions of appointment. And we have rejected under rule 4B2, my lords, that the wife of the deceased was employed as on the dates he sought for compassionate appointment.
Rule
4B2. In case, if I may read, my lords.
59.
Page 59 of the writ appeal copy which I have been served with.
Eligibility appointment.
Conditions for appointment, rule 4.
Page number
There is the
64.
condition for it.
have been served.
In page number 64.
In my copy, it is 59 minutes. My
In page number
apologies.
64, my kind. 64, yes. Subsequently, my lords, it has been struck down where, my lords, at bottom of the page, my lords, it's so 9/4/21, it has been Your mother was inserted, my lords.
Your mother was an employee.
Yes, my lords, she was working. And my lords, while considering the endorsements which have been challenged by the, before
What
the
is wrong,
learned.
what is wrong in denying the appointment?
Lord's law on the point is as on the date of consideration, what is the law I have to consider? The amendment, if my lords may see, is on 9/4/2021.
Amended rule is in
2021, 9/4/2021, that too by insertion. And my endorsement may kindly be seen, my lords, is on 2/11/2018 at page, my annexure D, my lords.
Page number
Rule four-
13.
Rule 4 was in vogue when the case was considered.
Indeed, my lords.
So that will apply.
My lords, when the endorsements were issued, my lords, in page number 39 and 34, if my lords could see that only the applicant does not satisfy under rule 4(1). That's all, my lords. No reasonings have been assigned as to what is the reasons have not been assigned.
For
My lords,
reasons for
my lords, with regarding to rule 4 subclause 1.
rule 4 will apply.
My lords, there are, my lords, A, B, C, D, there are several up to 6, my lords, and what is the reason with regarding to
Your
the?
case was governed. When the case was considered, this rule was in vogue and it will govern. Correct?
Indeed.
So that is also AIR 1984, Supreme Court, page 1314.
Lords,
In a
even,
different context. Mysore University.
even NC Santosh says, my lords, as on the date of consideration.
As on the date, so don't dispute with regarding.
Also in
to-
the compensatory appointment, Santosh or what? Learner single has referred it.
My lords,
Has been reiterated in the year 2024 also.
Santosh.
Para 19, my lords.
Santosh?
NC Santosh, para 19, my lords. May I read, my lords? Applying the law governing compassionate appointment called out from the above judgments, our opinion on the point at issue is that the norms prevailing on the date of consideration application should be the basis for consideration of the claim for compassionate appointment. And this has been reiterated subsequently.
The other
also.
judgment, PMS, last judgment. PMS is last judgment.
Lords, this speaks about, my lords, the amendment with respect to the same rule, my lords, 1996 rules, was interpreted, and it was held in para 10, my lords, that the insertion does not amount to retrospective effect, it is prospective effect. So as on the date of consideration, that is 2018.
It may be retroactive, but not
yes,
retrospective.
my lords.
So sorry, Mr. Discussion.
My lords, no reasonings have been assigned with in the.
Here this release.
Will kick it in the chamber.
Lords,
One more submission, my lords. My lords, the High Court of Tripura, it has, my lords, in 69/21, my lords, it's regarding to the legality of the notification. Whether an executive order can be given a retrospective effect, and further whether an application for compassionate appointment could be considered in terms of the scheme prevalent on date of its consideration, my lords, it has been referred to.
Heard learned advocate, Mr. What is your good name? Ajit Kalyan for the appellant and learned advocate.
Sridhar, my lords. Sridhar, my apologies, my lords, because of unhealthiness, my senior couldn't be present today.
Then you are more than this. Background
Sridhar.
you are?
I am Sridhar, my lords, Sridhar.
So and so for the respondent. Present in Kapil, in the section 4 of the Karnataka High Court. 26 July 23, learn a single judge whereby petition. Prisoner in the petition paragraph. Right. Or setting aside the endorsement of the order dated 2/11/18 received by respondent 1, Registrar General, as well as order dated 7/11/18 of the
Municipal District Judge has responded to hearing, whereby the compensatory appointment to the petitioner was denied. Full stop. For denying the compensatory appointment, on the ground weighed with on a single judge was that the mother of the petitioner was an employee serving under the establishment of High Court, whose annual income was ₹7,20,288. Full stop. The petitioner claimant for the benefit of compensatory appointment was the son of the employee who was deceased employee who was a bailiff and died on 22/12/16. Full stop. It was an eminently justified view taken by on a single judge paragraph that since the mother was in service and earning, the respondent, the petitioner could not be considered eligible to be offered compensatory appointment. Full stop. The authorities paragraph relied on Rule 4/1 of the Karnataka Civil Services appointment on compensatory grounds, Rules 1996, to pass the order denying the benefit of compensatory appointment. The said rule came into force with effect from 1/9/2021. Full stop. An argument paragraph was sought to be canvassed in vain on behalf of the petitioner appellant that when the employee died and the petitioner applied for compensatory appointment, so the said rule was not in statute. Said rule was not enacted. Therefore, it could not have been applied, and that the rules prevalent at the time of death of the employee on the date of making of application would have to apply to treat the petitioner entitled to the compensatory appointment. Full stop. In Mysore University versus so and so and AIR 1984 SC 1314. Check the page, comma. And I'll give the citation paragraph. The law is laid down in respect of the compensatory appointment only in NC Santosh versus State of Karnataka and others. 2027 SCC 617, where the Supreme Court has held that it will be the date of the
Para 19.
That the rules prevalent on the date of consideration of the application of the petitioner would apply and would determine the eligibility for granting or denying the benefit. Law on a single judge is taken into account the law laid down in Madhuri Maruti Vidate Supra. In paragraph 6, and has further relied on the decision of NC Santosh Supra to hold against the petitioner.
case held by the Supreme Court in Mysore University, Super, the rule, application of rule 4.1, which was brought into effect. Rule 4.1 could not be said to be retrospective when the question of consideration of the application of petitioner arose, since the said rule was applicable, said rule was in force, it would apply to determine the eligibility of the petitioner. So no error could be pointed out paragraph in the judgment and order of law on a single judge. The appeal stands meritless and it is dismissed.
Deeply obliged.
For that, since both the sides were represented by learned advocates, with their consent and request, the main writ appeal itself was considered on merits. And also, and so.
Number 5.
Very easy, Lordship. Lordship, the appellant has raised very basic and significant legal point in his petition before the single judge, Lordship. Am I audible, Lordship? Lordship, appellant has raised a very basic and significant legal aspect before the single judge, Lordship, and they paid for signing each page in the case diary whenever it is brought before the court, Lordship. The same prayer was rejected on the ground that there is no such specific rule mentioned in the Karnataka criminal rules of practice, Lordship. On this ground, my prayer was rejected. I am before this honorable court, Lordship. Lordship, kindly appreciate the fairness and transparency is the bedrock of every criminal investigation, Lordship.
Investigation is in progress.
No, Lordship, investigation is progress. Investigation is still going on. Some accused persons are not arrested. Investigation going on against those are not arrested accused persons, Lordship.
Yes, where is the provision for signing the diary at each page, Mr. Counsel?
Lordship, there is no specific provision, but it's implied. Whenever the court diaries are brought before the court, they have to peruse the court diaries. It itself shows that, Lordship, to authenticate that it is brought before the court.
So
And
there is no reason for us to lay down a new rule that the diary.
Lordship, kindly appreciate. The Karnataka rules of practice is not a law, Lordship. It is a guidelines issued made by the Honorable High Court of Karnataka of the state, Lord.
Apprehensions cannot be basis of the litigation and
Lordship, most of the state criminal rules very specifically mention that.
On a single judge elaborately considered everything. Every argument of yours is answered by a judgment.
Lordship, kindly appreciate the rules were made for the convenience of rendering justice, Lordship, and one of the most vital aspect is the check and balance from the illegal investigation, and which is done by in the form of maintaining case diary.
Everything is considered and answered by learned single judge. Every question, every submission of yours is answered by a judgment.
The single judge has rejected the petition on the ground that there is no specific rule. My humble submission is that it is not a law because the criminal rules of practice were made by exercising power under 227 of Constitution of India, Lordship. And maybe this aspect not been mentioned, but all other high courts, all other states, criminal rules, it's a very specific provision. Even I had in a tabular form, I have mentioned in which other state it is mentioned specifically, Lordship. Lordship, kindly peruse the table, start from page number 7, Lordship. page number 7. The High Court name is given, Lordship, Karnataka, Rajasthan High Court. The rule which they have framed it, police diaries not need to be part of the records. Then specifically, B, whenever the case diary is produced before the court during the course of inquiry or for the obtaining remands under section 167 CRPC, the presiding officer of the court concerned shall signature over it, and fact of making signature should also be recorded in writing, Lordship. Subsequently, the similar way that it is there in Andhra Pradesh High Court, in Telangana High Court, even Punjab, Delhi, Rajasthan, Haryana, HP, even in Bombay, Gujarat, Goa, these all specific rules are there, Lordship. Whenever they Lordship, then what will happen is, if the no signature will be there, then it will be open case for the agencies to manipulate anything, Lordship. And in this case, in particular, in the same case, there already allegations were made. Even they had fabricated the statements of the eyewitnesses. Even a complaint under 340 also has filed against the investigation officers for fabrication of the statements of eyewitnesses, Lordship, in the same case. In such kind of offenses, Lordship,
So ultimately, you want the court to legislate, Mr. Counsel.
Lordship, that is not a legislation. The rules are not legislation. The learned single judge has considered it as a legislation,
and that too only on
this
the
matter they are stating that the way the court cannot legislate. My
no
humble
boundary
submission is-
delegation, only apprehension that they'll be misused or tampered with. or
Lordship,
fabricated.
this piece of procedure is not a legislation, Lordship. It is a rule framed by the respective high courts for the convenience of the court procedures, Lordship. Even the preamble says so.
Who is appearing on behalf of the National Investigating Agency? You will be
Standing
appearing.
counsel. P. Prasanna Kumar, sir, standing counsel.
P. Prasanna Kumar, Lordship, standing counsel.
P. Prasanna Kumar. You give copy to him, to the council.
Certainly, Lordship.
Prima facie, we are not persuaded, but still you give copy.
Lordship, date may fix, Lordship, I will.
Date will be 12th of July.
Any date within this month, Lordship?
July. Give copy.
Seal number 6, Mr. B.C. Prabhakar.
Appear for the appellant, my lord. This is a case where,
Only 2%. What is your instruction?
my lord, your lordship wanted me to take instructions from the management as to from which date they are in a position to absorb on the last occasion. And I took time to take instructions from the management. My lord, I have discussed with the management. The management has got, the bank has got practical difficulty because this is, they are working as temporary employees. And they did not undergo any selection process, which is a must in the case of a public appointment.
We know.
And the entire order passed by the learned single judge is.
What is the total number of years they have put in? More than 20?
My lord.
What is the total number of years they have put in?
My lord, in fact, because of the pendency of the writ petition, my lord, right from 2009, I could not disturb them. And I have continued, though I would have discontinued.
Lord learned advocate, Mr. So and so for the appellant, notice to the respondents returnable on July 12. Full stop. By way of paid interim leave, the status quo shall be maintained. By way of paid interim order, it is provided that the status quo shall be maintained in respect of the service conditions of the respondents. Right? You will not terminate, that is all. There is swing notice. Status quo shall be maintained.
You will maintain the status quo.
Delay is there. Then Mr. Counsel will not be able to grant any relief, only notice. Delay is there. Only notice returnable. Delay is there. Well,
Number 7.
Lord, the appellant is one of the subsidiaries of the HMT Limited, created in 99. Lord, it was never a financially stable company. It had faced a sickness and it was before BIFR. Lord, the appellant is a subsidiary of HMT Limited. Lord, not being financially stable all through, Lord, it was facing proceedings before the BIFR. Lord, the government, the central government guidelines issued regarding pay revision, Lord, mandates that unless the financial health is proper, we cannot revise the pay. So therefore, the 1997 pay revision we had not done. We implemented it only in 2014. Lord, the writ petitioner retired in 2005. She retired in 2005. Lord, she claims the pay revision from 1997. Lord, the settled law on pay revision, Lord, a copy of the order passed by learned single judge and affirmed by the then Honorable Chief Justice, which I have placed in the writ proceedings, Lord, says that the company has got its discretion to decide when to implement the pay revision. So therefore, Lord, the pay revision implementation from 2014 is right. But the writ petitioner, Lord, who retired in 2005, claims pay revision from 97, and the learned single judge allows it on 2 grounds, Lord. Lord, kindly have a look at page 54, para 11. Lord, primarily, Lord, one, he relies on judgment of another learned single judge, which was already challenged before your lordship. The matter has been heard and reserved.
so will issue notice.
Lord, the
same is reserved.
And it is reserved by the other bench with Lordship Justice Dikshit.
I was just trying to connect.
May I make submission, my lords? May I make submission, my lords, with regard?
The identical question is
Please, my
was
lords.
argued and is reserved.
Only 2 issues, my lord, if my lords permits me, I'd like to bring before this honorable court, my lords. My lords, kindly see, my lord, the page number 117, my lord. It's a resolution passed by the government based on the recommendation made by the retired Honorable Supreme Court Judge Justice Mohan Committee report. It has recommended to implement the 1997 pay revision from
Mr.
1-1.
Kamath, you are not there in that.
I was not there, my lord. I was not there, my lord. My lord, after, my lord, it was reserved. There was one Rajasthan High Court judgment on that issue. My lord, I understand that copy has been handed over to your lordships and Justice Dikshit as well.
We accepted it with hesitation.
Anyway, my lord, this requires examination, my lord. At least, my lord, we'll have to await that judgment. My lord, the second reason, my lord, which the learned single judge cites is our own central government's office memorandum, in which we say if there is one company, you cannot discriminate between two companies, two units. Here, my lord, there are no two different units. There is another subsidiary company that is not a unit. It's a different subsidiary unit. It has got its own company index number.
Subsidiary.
It is a separate subsidiary. Not merely because that subsidiary, which is profit making, has granted pay revision from an earlier date, I cannot be compelled to grant pay revision from the same date.
And in the case reserved, this little different question is.
No, but there, my lord, the question would be from whether the company has got a discretion to implement pay revision from a subsequent date. That is the issue. Here, my lord, there are two issues. One, the eligibility of the writ petitioner. Second, assuming that she is eligible, then from what date pay revision has to be given. On the second question, my lord, lordship's judgment on the other matter will be relevant.
My lord, may I be permitted to pass on this with regard to the sick, whatever the senior claiming about the company is a sick industry.
We have to issue
In fact,
because judgment relied on
and
was.
please, my lord, and the facts are, two facts are different here, my lord. One is, my lord, they claim that it's a different subsidiary unit. In fact, the chairman and the managing director are one and the same for all these companies.
Madam, why don't you understand? The same issue is pending, awaiting a decision of this court in a
Please,
reserved matter. So this
Please, my
has
lord,
to be
may I be
subjected to
permitted to
notice.
pass on this, my lord? My lord, in page 1, my lords, it was on 6th November 2018, my lord, dated.
Heard learned additional solicitor, Mr. Ravin Kamath, assisted by learned Ravin so for the appellant and learned advocate Miss so the respondent. It was entirely a point submitted while assailing the impugned judgment and order of learned single judge that the decision relied on by learned single judge in writ petition number 2175 of 2022 was carried in appeal before this court and the judgment is reserved. It was submitted that the said case involves the similar point as involved in the present case. In the aforesaid view, notice to the respondents returnable on 15th July, full stop, by of aid interimly, the impugned judgment and order of learned single shall remain state till the next day.
Not, can it be 16th, my lord? 15th, there is some 16th. I'm good. Lord, seal number 35 is the contempt in respect of the same one. It may be connected.
35 will stand over to 16th of July to be listed with writ appeal number so and so.
I'm grateful.
In your delay in that, in this appeal, there is a delay?
No, there is no delay.
Yes.
Diria, I'm sorry.
There is a delay of 61 days.
Delay.
The only notice.
I do not precipitate the contempt.
So that they will not do. Let us see. We keep.
My lord, as already order is reserved.
Keep it early
Similar
then, early.
reputation.
We'll keep it. Delay, it is a procedure here not to grant stay once there is delay. And it is right. There also it was there. Unless the delay is content, how can we touch the main notice? That is the whole thing. We'll keep it early, 27th of June.
Very good. I'm grateful.
Seal number 8.
Please, my lord, there is, please, my lord, for the petitioner, for the appellant, my lord, there is one more appeal filed by my lords, the Punjab National Bank, that may also be connected.
R3 in the main appeal.
How come this comes? Yeah. No? This was not the vacation.
18 for 20.
Lord, there's one more appeal, my lord. It may kindly be connected. That appeal, my lords, is filed by the Punjab National Bank. Oh, my lords, it was just before vacation.
18.
The only request is to connect the appeal.
Please. Lord, it so happened, my lord, the order challenge here is of Justice Dixit. Justice Dixit was it, therefore it had gone, please.
But after 4 weeks, my lords, because one more appeal, there is already an interim arrangement. Please.
There's already a stay, my lord.
May I make a submission? I'm R3 in the main appeal. We have filed a separate appeal. Kindly, this may be connected with this. Producing it.
Right.
So number 9, Mr. Subbarao GS.
Lord, this is a connected matter to serial number 46 onwards.
My lord, this is that minimum wages.
Minimum wages.
Notification, 34 notifications have been quashed. Matter relying on the Raptor case, the court has directed to redo the whole notifications.
Yes.
46 batch is connected with this.
And for the respondent one, but we are ready. We are ready. This is a case of minimum wages, and twice they have taken time, and we are ready to for the man.
Argue.
And the-
Make arguments, my lord. We are ready to make arguments. We are ready to make arguments, my lord.
My lord, may I size this? Subject to lordship's pleasure. What has happened? The honorable judge has quashed all the notifications in which no employer has been made a party. Principles are naturally required. My lord, in every petition when we challenge notifications, this court was insisting that we make all the central trade unions as parties. Matter has to go back to the single judge so that it can be decided after giving an opportunity. Because we have not been implemented as a party.
Engage the senior counsel. We have engaged the senior counsel also, ready to address the argument. That's what my submission is. We have also engaged, respondent one has engaged the senior counsel. He will be appearing through VC from Chennai. My lord.
My lord, may I suggest this, my lord, subject to your lordship's pleasure. Since the matter, we have not been heard in the matter can be remanded to the honorable single judge to give us an opportunity.
That's a matter to be
That
heard.
is all the main question.
Let them address the arguments, and we will also
is my
address the
first
argument.
argument.
Then this honorable court can come to a conclusion whether making them a necessary party.
Supreme Court judgment, my lord, was on a question of sealing on DA by Raptor Brett, who was a very prosperous employer. They, as a side issue, it was raised, and Justice Kuldeep Singh said, all right, this one should also be added. That's all. After that, so many notifications have been issued. Raptor Brett is of 1992. How many notifications?
Several, every 5 years.
Every 5 years they have issued notifications.
revisions have taken place. Raptor breadth has no play at all. And Central Trade Union Organization, which challenges the notifications, knows that all these 5 notifications were done by the government from 1992. Revisions have been done. They have been parties in the committee. They were also consulted. We were also heard. And strangely, the Honorable Single Judge has quashed the notification. No arrangement is made as to which notification who should follow. Redo the notifications, applying Raptor breadth, whether Raptor breadth applies or not. We were also heard before issuing notifications.
There is vacuum, sir.
Well, the Raptor breadth, kindly see that judgment is of 1992. Notification revisions have been issued.
My lord.
And suppose the government again says, I'll apply Raptor breadth, I have to come back. If the government says we apply, follow the High Court judgment, we have to come back, Your Lordship. I know I can come again, but Your Lordship will have to say.
May I make one submission? My Lord, the government tried to resolve this issue, but none of the parties were willing to, my Lord, come to a common understanding. They said they would get an order at the hands of my Lord and then come back. Right on two
Your Lordship may
occasions.
say, without reference to Raptor breadth, government can decide the matter. Let them keep it in mind, but they should not apply it as such. I must be given liberty to tell the government you need not have to follow Raptor. How can it be, Lord? I'm sorry. Kindly see Raptor breadth for a minute.
May not be applied irrespective of the fact situation, but it has to be kept in mind. That's all. That is what this learner single.
And
May I make a
we all
submission,
must
my
be heard, but Your Lordship would approve.
May I make a
like
submission,
this.
my lord? Nearly about
Without hearing
37.
the employers.
Nearly
No,
about
first of all,
37.
First of all, you decide whether you want all of us to take Chennai or you will be here.
No, sir. No, my lord.
If you are seeking ultimately time, then we may not waste the time in deliberation. Your counsel is appearing. You want your counsel to appear?
Yes, my lord.
Then we'll keep some other day. When shall we keep? We'll on that day we'll complete the matter.
12th, my lord. 12th.
12th. All right, 12th.
12th of
June.
Not this one. This month.
Yes.
Maybe.
Whenever all of you will, you know.
15th, my lord.
15. Okay, 15. 10 out to 15 at the request of counsel for the parties.
15 Saturday.
This is a Saturday, my lord.
Court will sit for your sake. Don't worry.
15 June will be
No,
holiday.
15th or
Saturday.
14th, Your Lordship. 15th is Saturday, I believe.
14th can be kept. 14th or 19th, whenever. 19th
19th would be better. Because
19th will be.
Friday after, my lord, may.
19th.
About 46, my lord. Interim orders and extended.
Wherever interim order is there, it will be extended.
Connected is 46.
46
Not
will.
this, serial number 9 connected to 46.
But broadly, you can.
Sorry, no?
Broadly, it is understood that you can go there and submit.
That is very shortest way.
No, we'll consider your
I thought of it actually, for your lordship.
Not that we are shutting down your argument.
Suppose my lord says, go there, urge all these points, what is there? There is one way of disposing. But
Not
is it-
one of deciding. You say disposing of, we are say deciding.
Just one submission, my lord. The problem with we going to the government is that now the single judge order has told redo the notification taking the objections.
Objections
So,
only union.
Of the union, say.
We were not party to it
We
at
won't
all.
be given authority to go before the government as well.
Those things will take care of. All those things, minor things.
Not,
in your role.
we, both of us will be here. I don't do it.
Let us,
My lord, serial number 9 was a connected matter to serial number 46. Interim order be granted.
Will be extended.
To be granted.
Yes.
It has been extended.
It's a fresh matter for admission.
fresh matter, all.
My lord, no action is being taken because the matters are pending before my lord.
But in this other group, it is operating. 14,
Serial number
9,
Yes, ma'am.
That is the one which was called.
which is called out. So what is the interim order operating in that group?
Yes,
No precipitative action.
not to precipitate.
Till the next date of
So 9, not writ appeal number 644/24 heard learned senior advocate so and so, assisted by learned advocate so and so. For the appellant and learned additional government advocate for the respondents, appearing upon service of copy of the appeal in advance. It was stated that the issue involved in this appeal is identical to one involved in the group of writ appeal, which is writ appeal number 24 and connected appeals. Full stop. Notice to the respondents returnable on 19th June. Full stop. Since in the cognate group, the interim order is operating, the appellant here is entitled to be granted this relief on the similar line. It is therefore directed that the respondent shall not take any precipitative action till the next date.
Much obliged.
In fact, I expected my lord.
Be condoned, madam. Delay application, delay are condoning and this order is passed. Any other priority is there other than the law? Delay is condoned by separate order. Union, who will be appearing for union?
Mr. Muralidhar.
Well, Union of India will be appearing.
Union of India is not involved.
Trade union.
State of Karnataka.
The trade union.
You are appearing.
I am for appearing for trade union, R1.
All India Union, Trade Union Congress, AITUC.
Take down the appearances.
No, we are the authorities representing R2, Engineering and General Workers Union. There are two unions, my lord.
So who is for number 1?
R1 is KB Narayan Swami and Muralidhara. I am Muralidhara. I am appearing for R1.
Appearing for R1. So all are represented.
Yes.
All respondents.
Yes.
So take down the appearance. Delay is condoned. Delay condoned and in main appeal notice and the interim order.
So for complaints in contempt matters, seal number 10. Mr. Prabhu Godathulagi.
They have not complied the order.
Hmm?
They have not complied the order. The fact is this.
May I make one
I am-
submission before my learned friend
Lord,
commences? What has happened on the last occasion before this honorable court is that my learned friend took time to go and approach the learned single judge, wherein a writ petition is filed seeking for a direction not to disperse the compensation amount. There's an interim order granted by it. My learned friend wanted to go and appear before the learned single judge.
Yes,
My
may I
learned friend appeared before the learned single judge. There, the BDA has also filed an application seeking permission before the learned single judge to deposit the award amount before the civil court.
May I make
Lord,
some-
this is the situation, Lord, wherein on last two occasions, the complainant took time to approach the learned single judge. Thereafter,
No, my lord.
matters.
Sorry, my lords. I didn't not took the time. The fact is this, lords. Lords, even lords, I had made an application for impleading in the lord that writ petition also. Lord, he himself is objecting for that, lord, my impleading application. First thing. Lord, the fact is this, lord. I am the owner of lord the 5 acre, lord the 24 guntas of land. Lord, which is acquired by the Lord of the respondent, Lord of the acute hearing. Lord, in the year 2004. Lord, neither Lord of the paid the compensation nor Lord of the developed land has been Lord given it to me. Lord, since Lord, they have not Lord paid the compensation, I have approached this the Honorable Lord Red Single Judge, Lord, seeking direction to them. Lord,
what is the inquiry to be completed?
Lord, that inquiry has been held, Lord, it came to their knowledge that Lord, I am the owner of the property. Till that, Lord, suppressing that fact, Lord, they did not place that record before this honorable court.
Inquiry is completed?
Lord, inquiry was completed. They found that the documents are documents which they claim are genuine, but subsequently, Lord, their power of attorney has sold the property in favor of other people who have filed a writ before this honorable court. And
That
saying
also false.
Lord, and they say, Lord, there is this stay of disbursement of compensation. Lord, I have produced it along with my compliance affidavit, Lord, filed long back, Lord. Thereafter, after hearing that only, Lord.
But you have to deposit the amount, not
not
to pay to anybody.
Not to pay to anybody. I have filed an application before the learned single judge seeking permission where, Lord, the entire issue has been adjudicated now. Now I have filed an application before the learned single judge seeking for a permission to go and deposit because there is a stay order operating against us.
But why are not depositing the amount?
Not there is a stay
Lord,
order
this is
operating
5 acre,
against it.
24 guntas, Lord, there, Lord, in that writ petition, only Lord, a few, Lord, of the petitioners, they are Lord, telling that, Lord, they are holding few sites, Lord, is within half an acre. Lord, now, Lord, he wanted to take advantage of, Lord, of the writ petition order.
But if you go on arguing, we will not be able to put any question to the council.
Please.
Why you are not deposited the amount?
Lord, there is an order. Lord, the Lordship may kindly take my compliance affidavit at page 10, Lord, where I have filed. There is an order.
Irrespective of any proceedings before the single judge, transfer of the land, you have to deposit the amount.
Lord, there is stay of disbursement of the compensation by the learned single judge, where I have filed an application. Now, in view of all this, I want to go and deposit, permit me to deposit. This is the application which we have filed before the learned single judge. There, my learned friend.
There is a question of application, there is direction of this.
Lord, but there subsequently there is a direction by the, in another writ petition, there is a stay order, Lord. Lordship may kindly see page 10.
Page 10.
Please.
Writ petition filed by?
Place
It is filed by page 10
of my compliance affidavit.
Lord, kindly take up that matter also, Lord, here, Lord, the truth will come out. Lord, fact is that, Lord, few sites, Lord, in that writ petition, they claim to have, Lord, of the sold those few sites, Lord, within half an acre. Lord, in fact, Lord, he hasn't sold, Lord, any site to anybody. Lord, that, Lord, the 4 GPA has been created. Based on that, Lord, they come upon, Lord, the possession. Lord, in fact, Lord, in the year 2004 itself, Lord, land was, Lord, the vacant. Lord, BDA has not taken possession of that land. It is their report also shows the same thing.
This is only the respondent BDA is not to disperse the compensation.
Yes.
So nobody prevents you from depositing.
Lord,
You go to the direction to be complied with.
if that is so, Lord, I'll deposit tomorrow and come back and report it to your Lordship.
Right. This
Lord,
order does
because
not-
that is why
This order only prevents the disbursement, not deposit.
Yes, Lord, that's why an application was filed before the learned single judge seeking permission.
Read the direction at page 17. The Bangalore Development Authority, in tandem with the submissions now, depending on the amount outcome inquiry, shall ensure that the amount determined in terms of award dated 894 with interest
in accordance with law within law is
deposited
under section 31 of the act, if for necessary adjudication.
Deposit.
Yes, I shall deposit. Lordship may have it on Thursday, Lord. By then I'll go and deposit.
And Lord, that inquiry reports to be placed before this honorable court. Lord, they don't want to, Lord, that.
We are only contempt court. We are not concerned with inquiry report. We are concerned with the completion of inquiry. Learned advocate Mr. So-and-so for the respondent Bangalore Development Authority stated that in terms of direction into bracket Roman small 3 of the order of learned single judge, which is brought under contempt, the amount awarded as per award dated 8/9/2004 together with the interest shall be deposited with the competent court.
Please.
Within
Lordship may fix a time.
in 3 days, put upon 10th of
Please. May I make one request also, my lord? Let them not go and contend that I undertook in a contempt
It is
petition.
it is provided that the apprehension is expressed that the amount may not be accepted in view of the order dated 20, which is the date 27/7/23, passed in writ petition number 1633/23. The copy of the said order is produced on record, which does not in any manner whatsoever bars the depositing and does not stand in conflict with the opposite direction. Also, the said order only provides that the respondent BDA shall not disperse the compensations.
Great.
Stand or to 10.
Please. Oblige.
Case number 11, Mr. Sharat Kumar Shetty.
Writ of mandam is. writ of
Compliance
man-
affidavit has been filed.
Not-
Compliance affidavit has been filed.
no. I'll verify your lordship because I'll get the
What
instruction
is
from the
it?
party.
Some representation about the
It's reflected in my father name, your lordship. my father-
Saguwali. What is Saguwali entry?
Lords, we have entered the revenue entries.
It's in my father
Inheritance
name, your
also.
lordship. My father died in the year 2003. So all the family member has given a NOC to me, and that also have produced before the authority. And again, your lordship, reflected in my father name.
All the legal
have to
heirs
go
name
there.
also has been reflected.
So that is the difficulty, your lordship, because I have given a representation in the year 2003.
They have
From last
decided.
10 years, your lordship, I'm
They have decided now your representation. What is more survival?
kindly. Because my name should be reflect your lordship, instead
Then
of
you
my
challenge
name, your
that
lordship.
decision.
Instead of my name, your lordship, they have reflected my father name. My father died in the year 2003.
That is not the domain of the contempt court.
That's even the complainant's
Where
name is
is your
reflected.
compliance affidavit?
That's page
And
number.
what you have decided, page?
Page 2, my lords, we have stated in paragraph 3.
Paragraph?
We have entered the name of the father. Thereafter, we have entered the names of all the legal heirs also. It's produced in the affidavit, my lords, along with the RTCs and mutation records.
All the family members given NOC to me, your lordship, to change the name of petitioner. That also placed before the authority.
Lords, we have stated,
Certificate
we
also
have received
produced.
an application for mutating the name of the legal heirs of the deceased original grantee. Accordingly, we have entered all the legal heirs' names. Now, if the complainant has made another application, that is a different cause of action.
On a single judge by order dated 11th July 2022 directed Tehsildar, Koppa Taluk, Chikmagalur to decide the representation of to consider the representative of petitioner. First of the representation was made in relation to issuance of Saguwali chit extract. The petitioner filed a writ petition and prayed for direction against the said respondent to decide the said representation. Full stop. On a single judge directed to take a decision within stipulated time. It is this order paragraph which is brought under the contempt jurisdiction of this court. Paragraph. The compliance affidavit filed by the respondent indicate that the representation is decided and the exercise of issuance of Saguwali chit extract is undertaken, which is reflected in the revenue records annexed along with the copies of which are annexed along with the compliance affidavit. Full stop. In the aforesaid view, nothing survives in the present contempt petition. The contempt proceedings are closed. Full stop. If the
complainant is dissatisfied with the actions taken by the respondents, always open for the complainant to independently, to institute independent proceedings. Before approved forum, in respect of which this court does not express any opinion on merits.
Number
Present
12,
contempt application is disposed of the court.
number 12.
So the accused in the matter, Manoj, by virtue of a complaints affidavit dated 3rd of April 24, the order of the learned single judge has been complied. Copy has been served to my learned friend.
What had happened in this matter is the Assistant Conservator of Forest, my lords, had admitted, my lords, that he has taken in 14-acre 20 guntas of land belonging to the petitioner within the solar fence. Kindly see Annexure B, my lords. Based on this communication, my lords, an undertaking was given by the government advocate, my lords, that within 8 weeks, a survey would be conducted and the land belonging to the petitioners would be handed over. Now, my lords, there is no solar fencing as such. There was a survey conducted. An endorsement has now been issued, my lords, saying that no land belonging to the petitioner is with the forest department. To that extent, my lords, but what has happened in the meantime, they have dug, my lords, trenches, elephant trenches, almost 10 feet deep and almost 2 to 3 kilometers in length, my lords. So we've given a representation saying that handing over means handing it over as it was. So I leave it to your lordships, my lords. Either in this contempt petition, your lordships could direct them to fill up those trenches, my lords. Those are elephant trenches. This is a forest area, my lords. The land of the petitioner.
Where is your compliance?
My lords, dated 3rd of April, my lords, page number. The joint survey report, my lords would find it at page number 17, my lords, annexure R3. Subsequent to the joint survey report, an endorsement has been issued, which my lords should find it at page number 20, annexure R4. In the joint survey, the endorsement, my lords may kindly come to page 22. The last paragraph in page 22, my lords. As per the points above, the last line, my lords, they're not in possession of the forest department.
Kindly see page 18, my lords. What led to the petition? Kindly see page 18 of my petition.
My lords also may peruse the order of the learned single judge at page 14.
And that's why I'm making a submission before this honorable court, my lords. Page 18, the Assistant Conservator of Forest said, my lords, 14-acre 20 guntas is within the IPT and solar fencing constructed with the department. Now they say it is not.
So survey was undertaken, you
Yes,
were
yes.
present.
Yes, my lords,
Verified the boundaries and it is found that no land is
can I?
the
My lords,
possession of.
there is no solar fencing. I'm not saying survey was not conducted. Everything is fine, my lords. But when the land was with the department, they have dug trenches, my lords. They are called elephant trenches, so that the elephants do not go out of the forest boundary. They have dug trenches within our boundary. So I'm requesting this honorable court, either in this petition, your lordships may direct them, or grant me liberty to go again before the single judge, asking them to either of the two, because the elephant trenches, my lords, is around 10 feet deep and 10 feet in width, around 2 kilometers in length, my lords. So kindly grant me liberty.
We'll grant
for,
liberty
your lordships.
to challenge this.
Yes, please. The elephant trenches. Now the department doesn't have my land, my lords. To that extent, yes, my lords.
All right, we'll pass the.
Please, my lords, oblige, my lords.
I just request for the liberty, my lords.
Yes, yes, we'll be reasonable.
Please.
Oblige me.
Number 13.
So I appear for the
Petitioners Council. There is a part compliance affidavit filed saying they're still in the process. But if I may say so on a lighter note, orders passed in July say last year saying within 4 months, they're citing Lok Sabha elections. I did not know that they're also into astrology. It's, I don't know how they can cite something that was announced, my lord, in March of this year. Of course, they're saying they'll complete it in 4 weeks.
So this inquiry is completed?
No, Murad, I'm told paragraph 5,
Completed.
they say it is almost complied, but they require another 4 weeks. Paragraph 5 of their counter affidavit.
Lord, 4, my lord, 4.
I'm sorry, there is some error in numbering, I apologize. I mean, on their part, but nonetheless.
Matter was reserved.
Bottom of paragraph, page 4 of their counter affidavit. There are 2 paragraphs with the number 5 in their counter affidavit. The last paragraph of page 4. They say they had some progress but not completed the work.
So if it is compliant.
Please, my lord, your lordship may stand over by another 4 weeks, no difficulty about it. So good.
So it is possible.
No, my lord, your lordship may kindly keep the matter pending because I'm not yet complied.
Can be closed.
Only order they are committing. We'll say that.
You have filed affidavit.
But there is a
stating
reason,
about-
may I just point out? For a minute, please be kind enough to see. They say that the person against who they have to take action has filed a suit. Now, I don't want them to come back and say that there is some further obstruction. It was already taken almost 1 year.
Lord, now, my lord, have you
One minute,
undertaken?
one minute. My learned friend, my lord, should be a little fair. He's not completed the work. He now says he wants 4 more weeks. All I'm asking is, your lordship may keep it after 4 weeks, my lord, and if it is closed, I'm not on the result of the inquiry. It has taken them almost 1 year to complete the inquiry, and they're citing Lok Sabha elections, which, my lord, were announced in end of March, if I'm not mistaken. Though your lordship's orders is of July last year. All I'm saying is, your lordship may kindly have it, my lord, the first week of July or so, let them comply, and then matter could be completed. No difficulty. Because without that, my lord, I'm not too sure. Despite your lordship's orders. My lord, in the previous paragraph, they talk about some suit filed by that person. Very interesting, my lord. That suit appears to be now asking for an injunction restraining them from taking action. So there's something appears to be a little more than which meets the eye. That's why I'm pointing out.
Suit may have nothing to do with the inquiry.
No, my lord, it in fact is asking for an injunction relating to that. Would your lordship be kind enough to see page 21 of their counter affidavit?
Injunction against the inquiry.
But yes, they say permanent injunction in favor of plaintiff against defendant the KADB, restraining them from doing any act in contravention of the lease cum sale deed, restraining them from interfering with their possession. That is, my lord, directly opposed to what your lordship's order would be, which says that they have to take inquiry and take resumption if it is necessary. Your lordship's order, my lord, the culmination would be resumption. Injunction, if granted, would be exactly to the opposite. That's why, my lord, I'm pointing out. Your lordship, let them complete the inquiry. Your lordship may stand over by 4 weeks and then we'll
Keep it over 3 weeks.
Lordship, great.
1 week has already passed.
Yes, my lord, that is so.
A statement on oath has been forthcoming in the compliance affidavit that though the inquiry directed to be completed by a single judge has already been over. However, order could not be passed, and that order will be passed within 4 weeks. It is the say of the respondent that the order was not passed on account of code of conduct prevalent, on account of the then impending Lok Sabha elections. Since the statement is made that the
order will be passed and the directions of learner single judge will be finally complied with within 4 weeks. As per affidavit dated 29/5/24, put up on 9th of July.
Lord, it is the order of the learned single judge and this court. It's orders of this court as well as learned single judge.
So comply with.
Please, great.
Urgent, December 15.
Hearing for the government.
Lord,
matter.
this matter.
For one of the respondents were also included. One of it relates to manual scavenging and the implementation of the Prohibition of Scavenging Act. The government had filed a detailed compliance affidavit as per the directions of this court. And my lords, after the compliance affidavit was filed, we also filed responses. And my lords, I want to take my lords through the compliance affidavit because there are certain important issues which still have not been complied with. And that is actually evident from their compliance affidavit. If my lords could kindly see the 25th January 24 compliance affidavit, which the government had filed.
Before the matter is taken up on merits, I'm so sorry, my lord, I'm interjecting. I'm here, my lord. Mate, please, here, my lord. I'm on this side. I'm here, my lord, before your lordships. Lord, before the matter is taken up on merits, may I submit, my lord? I'm here, my lord. I'm not on VC, my lord. I'm physically appearing before the lordships.
Yes.
This side, my lord, I'm sorry. The matter is, my lord, the one private matter also got connected with this, which may be, my lord, disjuncted. And other PILs all may be heard, and my learned friend can, my lord, continue with the PILs per se. Because in the PILs, my lord, this private matter also got involved only for the purpose of disbursement of compensation.
Yours is a private matter.
No, not mine, my lord.
My lord, if I may submit on that, my lord, I have actually moved the matter for today, my lord. The matter was originally posted on 10th of June. My lord, in 15.4, which is writ petition 815 of 2024, my lords may note on the last date, the petitioners had deposited an amount of 20 lakhs, my lord, and my lords had directed that the amount be dispersed to the legal representatives. The office, my lord, has said that since our impleading, we had filed an impleading application on behalf of the legal heirs of the two workmen who had passed away. The office has said, my lord, since our impleading application was still pending, that they would not be able to disburse that amount, my lord.
Directed.
Please, my
Despite
lord.
direction, there is
Despite
some.
that, my lord, this is the orally they had informed us. That is the reason that in fact this memo had been moved by me for today, my lord.
In fact, we last time directed to.
Please, my lord, it has been directed to be released, my lord. In fact, at
18.3
para
order
6, my
passed, my
lord.
lords.
18.3 order.
Yes, please, my
18.3.
lord. On 18th March, my lords had directed that the amount be disbursed to the legal heirs. In fact, it is also said, my lord, that the registry is to verify the identity and credentials of the recipients. At paragraph 6, my lord. The registry shall verify the identity and credentials of the recipient and transfer the amount of rupees 10 lakhs for each. But my lord, they have orally informed us that our impleading application which we had filed, that remains pending. And therefore, my lord, they had said that unless orders are passed on that, they would not be able to disperse the amount. That is the reason that I had moved this matter for an earlier date.
Legal as a party?
They have filed an application for impleadment, my lord. That impleading application remains pending before my lords. It has not been allowed as yet.
In fact, my lords,
There are
petitioners
two
themselves had
applications.
filed application for disbursement of amount along with the details
Who
of
is this officer?
legal
Sir,
days.
court officer. Who is the officer not complying with this direction of disbursement?
The family
Is
is
it?
waiting for the compensation.
Who is responsible for
My lord,
this?
I'll verify, my lord. They were informed that they've
May-
orally informed us that since that application remains pending,
May make one
that
submission.
application has to be.
Which officer has said you
I'll
know?
verify and I'll make my
And you have
submission.
not verified, then don't make any statement.
No, my lord, I have verified, my lord.
Either way,
I'll
we are
just find the
equally strict.
details of the officer, my
We are
lord.
equally strict to your vague statement. We are equally strict to the officer who are not implementing the directions of the court. So who has said no? Nazar? No. Where from you will get the disbursement? Of Nazar's office?
I'm sorry, my lord.
Where from you will get the
My
disbursement?
lord, I'll verify with my colleague of who the exact officer is. I'll make my
2:30.
submission, my lord. Please, my lord.
Meanwhile, the main petition is for implementation.
That will do. That will
That's
proceed.
why, my
You
lord,
want
this
to proceed?
issue,
Lord, may make one
Private
submission.
issue, my lord, is the court. This may even be after the dispersal, my lord, this issue may be sent back to the honorable single judge. Because except that issue, my lord, nothing remains. The actual adjudication has to happen. And in PIL matters, my lord, larger issues are being espoused. Larger issues are being espoused.
Which appeal? Appeal is there? Appeal? No.
No, all of them are writ
Three-
petitions.
They're all public interest writ petitions.
You read up. What is read up?
Writ petitions are different, my lord, where my friend is asking for the disbursement.
That may be disjuncted because otherwise, my lord, the larger issues will not get espoused.
Who is implementing this order? Call him. Who will be implementing this order? Find out and call him. He must be here at 2:30 before the. Blood. Yes. 2:30. 2:30 will take. Lord, may make a mention, my lord.
fact-
May I make a submission, my lord. Lord, in this case, my lord, learned friend says that she has filed an. Give me the writ appeal. Now, why writ appeals are tagged with this?
Writ petitions, my lords.
My lord, that was pending before the
No,
learned
writ
civil
appeal.
judge.
If
Lord, in the
those
pet-
impediments are allowed, it can
My
be
lord, in the
disposed, my
petition,
lord.
15.3. Petitions. No.
Point 4 is.
My lord, in the petition where the amount has to be dispersed, my learned friend says she has filed an application for, to bring the LRs on record. My lord, if those applications are allowed, my lord, they would get the amount.
Allow the application.
No,
Our order was certainly not based on the allowing of.
Please, please. That was an independent direction, my lord, and there was specific direction to
It
disperse.
has
the
to be compliant. If it is, some officer is resisting the order, he'll see the red light of the day. He must be here. Why this disbursement is not taken place after a month?
3 months. Great.
Call also RG at 2:30.
This number 16.
Yes.
This contempt petition is by ex-military personnel of about 50 members who have made an application for grant of lands after their retirement. It has been taken up, processed, and the lands were also identified. And at that time, some unforeseen hands had come in and they did not pass any orders. Therefore, we filed an application for mandamus to consider our applications, my lord. The learned single judge, your lordship may kindly find the operative portion at page number 40, my lord. That second para, the learned additional government advocate on instructions of the official respondent submits that the claim of the petitioners for allotment of lands would be considered and disposed of within an outer limit of 3 months, and that even individual orders to be made on the said application shall be sent to each one of them as well within the said 3 months itself. My lord, within 3 months they did not. Therefore, we have approached this honorable court, my lord. Now they have filed an application, the counter affidavit saying that we have complied with rejecting our application on 2 grounds, my lord. One is it is coming within the forest reserve area. The lands which were sought to be granted to us is coming within the reserved forest area, my lord. My lord, that statement which they have made is false in the affidavit. Therefore, I am saying the affidavit of compliance filed is a false affidavit, because your lordship may kindly see. In fact, the joint survey was held of both these revenue officials and the forest officials, and they have drawn the spot mahazar, the joint measurements, and they found that the lands which are to be granted to these complainants falls outside the forest area according to the joint survey, my lord. Now they are again, after finding that it is outside this forest area, reserved area, sketches were prepared, individual sketches of 4 acres to each of the complainants. Now, after exercise of all those things, now again in the contempt proceedings, they say it is coming within the forest area. Your lordship may kindly see, I have filed The counter affidavit, my lord, it is at annexure B3, my lord. Annexure B3 is the joint survey report. No, in the petition itself, my lord, I have filed annexure B3, main petition. It is at page number 56.
So what was the affidavit filed?
My lord,
What was the undertaking filed?
undertaking within 3 months, they would consider, my lord, saying that our
Where
applications.
where is that page?
It is in the order itself, my lord. It is at page number 14, my lord. 41.
No, undertaking.
Undertaking. In the
the compliance
second
affidavit,
para,
Your
in the second para 40, page number 40 of the impugned order annexure A. Contempt petition, my lord. Paragraph number 2, the learned government advocate on instructions of the official respondent submits that the claim of the petitioners for allotment of lands would be considered and disposed of within an outer limit of 3 months, and that even individual orders, so and so.
No, it was in writing or the statement was?
The statement was recorded.
But then it is stated by learned single judge that the
Yes.
placing on record the undertaking.
Yes.
So it is physical or just statement was made?
Just oral statement. I will have to verify.
Only statement was.
I will have to verify, my lord, because I was not appearing. Transferred brief. But in the operative portion, it is clearly said, in view of the fair stand taken by both the sides, this writ petition is disposed of, placing on record the undertaking given by the official respondents through the learned AGA as to accomplishment of task in a time-bound way. If delay is brooked, the jurisdictional official shall run the risk of being hauled up for contempt of this court. All contentions of the parties are kept open.
But which direction? What is not complied with?
This is the
They're
undertaking
considering
which
the
they said they would consider. Paragraph number 2.
So we are asking where is the undertaking?
That I will find out, my lord, because it is the court order. I will have to find out.
It's
whether
only a
it is-
recording of submission. Name of the petitioner. Yes, why should you not comply with your own?
We have complied in the compliance affidavit, Your Lordship.
That
The
is the
land
only-
that is sought for,
Pardon?
the land that has been sought for allotment, Your Lordship, this comes under a reserved notified forest. And the revenue authorities have no powers. Here it is a case, they have sought for directions being an ex-serviceman. And they are entitled for certain lands for the services that render to the nation. Now, Your Lordship, what has happened is they have filed applications. Their applications were considered, and whatever lands that they say that is available for grant. Now, even there is a ceiling limit for the land that has to be granted. And we have considered their representation and given an endorsement saying that, see, that land is a forest land and that cannot be granted. No, they will have
My
to challenge that
respectful submission
endorsement, seeking
is-
either alternate land or whatever is the notifications that are prevailing as of now by the department for the benefit of the ex-servicemen. Those will be considered, Your Lordships. Now, these lands, Your Lordships is aware that the state governments also now, in the judgment of the Honorable Apex Court, cannot deal with the forest lands.
Annexure B3 in the main petition, Your Lordship may kindly peruse. Even according to the Forest Department and the Revenue Department, after joint survey, have come to the conclusion that the lands which are sought to be granted to the complainants are falling outside the forest reserve area, my lord. Your Lordship may kindly peruse page 56, my lord. Para 3. Page 56. Joint survey report, where forest authorities, revenue authorities jointly surveyed the land page 56, joint survey work of land, that is paragraph number 2, para 3 is relevant. In resurvey number so and so, as per so and so. However, as per the notification of the central government, the area requested to be outside the MA Doddi Tiger Parvas. In this present naturally grown plant and trees are standing. Complainants have made the application in 2012, my lord, from the past 12 years. I also filed my counter affidavit as a reply to the complaints affidavit filed by the
Where is your compliance report?
complaints affidavit.
It's filed on 5th of September. 22.
Dated 14/9/22.
14/9/2022, it was filed, right? Is there? Yeah. Complaints affidavit is filed.
Relevant paras are at paras 7 and 8, my lord, of their complaints affidavit. In this, they say that the lands sought for grant are notified forest lands, which is false according to me, because in the joint survey held by the forest officers and the revenue officers, they themselves have said that it is falling outside the forest reserved area, and that therefore they have processed my application till the stage of identification of the lands to be granted to each one of the complainants, that is 4 acres each. Survey was done, lands were identified. Later on, they did not take any action. Therefore, I approached this honorable court. After hearing at that time, in the midst, the learned government advocate has given that undertaking, saying that they would consider. So my application was processed from 2016
individual
itself.
endorsements have been issued.
Individual, 4 acres. They have identified. Sketches were prepared.
All the 53 complaints, individual, right? Individual endorsements have been issued.
I have said so in my reply to the complaints affidavit, my lord. Dated 6/3/2023, I have filed my reply.
Contempt is evident. Your committing of contempt is evident because the very person gives report at page.
Yes, my lord.
5, that survey number 77 and 70, 71 and 77 are available to be granted.
Only.
And the very officer, very tehsildar, passes the order, who has passed, as my brother is rightly pointing out, as the same person has passed, has filed the affidavit, who has passed the order at one point of time earlier that these lands are available.
But those lands, your lordship, are available and now they are notified forest.
No.
They will kindly produce a notification of the forest department. Here, he claims 53 people, each of them are claiming 4 acres.
That will amount to about 250 acres. Even in the report that he read, it says only 21 acres is outside the forest boundary.
Now it is notified as forest.
It is always notified as forest.
Not now, my lord. Long back, they said, then thereafter in 19, they themselves have referred to the notification, which says it doesn't, that is what annexure B3 I have read, my lord. Page number 56. They, for 4 to 1942 notification, my lord.
different.
Yes, my lord, same land, my lord.
They say it's
You
70.
are also showing same line. Main road is covered. Ah, yes. Thus, there is an apparent inconsistent stand taken by the respondent authority and irreconcilable facts are stating. Full stop. Also figures on record. Report dated 17/6/21 by the office of the Tehsildar, in which also the said lands are liable, are treated as grantable and not to be the forest land. Full stop. The Tehsildar is directed to file a clear and unequivocal affidavit clarifying the above discrepancy and the conflicting stand emanating from the record. Full stop. If the affidavit which may be filed by the Tehsildar does not satisfy the court, comma, a stern action will follow. Put upon 12th on 2nd of July, on which date the necessary affidavit shall be filed. Otherwise, we'll hold up the Tehsildar.
Yes, sir.
This immediately.
We will file a better affidavit.
Yes.
Court is not audible, my lord.
Yes.
My lord, if it is 230 matter, my lord, serial number 69.
69, what do you want?
230 matter, my lord.
Sir,
We'll take up, wait, we'll take it.
Please, man, please, sorry, man, sorry.
Yes, who is present? Who is present? You know why this amount is not released? When there is court's order, you need not seek any claim.
Yes, sir.
So henceforth, take care. Is a clear order? So why did you not? For 1 month, it is 3rd of 18th of March.
Corona period, there is, if it is for a payment, transfer payment, IAS should be.
Are you court?
According to.
Are you court? Then do it immediately.
It is a lapse.
Otherwise, will come very heavily. You must abide by and comply with the directions immediately. You need not seek any clarification from the parties when there is court order. To be released today. Please. After verifying identity, don't do it mechanical, madam. Verify the identity of the claimant. But in whatever procedure you follow. But do it fast.
Also, my lords,
Now this when will take.
this matter, my lords.
We can take up the main matter, which is for the implementation of the law on.
The matter was
My lords.
adjourned to 10/6/24, my lords. My lords, the matter was adjourned on 10th of June. Because the monies were not dispersed, the memo was moved and the matter was listed today. My lords, for the merits of the matters, my lords, a date may be fixed. We have filed our compliances. We are ready to argue.
My lord, the
Council
compliance
said them something
Yes,
is left out.
We have filed our compliance. If they have any grievance, my lords, a rejoinder may be filed. We'll get it clarified.
My rejoinder. In fact, compliance was filed in January. Time was given for us to file our rejoinder.
Madam, you
We
are
have
seeking
done
time?
that.
Please, I'll
For-
take.
For what?
My lords, they say they have filed the rejoinder. We'll have a look at it and consider, we'll have it clarified and get instructions from the department.
Rejoinder is already on record.
Reply has been filed.
Reply is filed.
Reply to
I
their
just want to
compliance.
point out, my lords, in fact, even meetings under the act, meetings at the state level, which are supposed to happen twice a year, have not happened. Basic things like that, which are in fact part of the directions of my lords, that the implementation of the act has to happen in a very meticulous way.
We'll fix a day and on
Please,
that day we'll
Willis.
proceed. But in the meantime, you set out your points which
Very
are,
well. We have filed our reply.
which are required to be
Set it.
addressed by them
Very well.
still. So that it is clear and we may not have go to
Please.
My lords,
consume time more.
in the meanwhile, my lords, 15.4, my lords, a private petition, my lords, nothing to do with all the three
That may
main
be, my lord,
petitions. my lord.
disconnected
That will be
because
disconnected and sent back to a single judge, my lords.
because the individual issues may be exposed before the single
Single
judge only because it will not disturb the.
Which one?
15.4, my lords, where
Private-
the amount was released, my lords.
On that day it can be done.
No, my lord, this matter requires a detailed deliberation and therefore, my
On
lord,
the facts
if it gets admixed with
I-
these batches of cases, again, individual issues will surface, my lord, there.
It is not PI,
It is
It's
not
not a
PI, it's a
PI.
private petition filed by the industry.
Since it was in respect of the same issue, my lord, it was taken up, but it can be,
Yes,
it
on the
can
same
go back
act,
to
not
the.
on
Can be
same issue.
delinked, my lords.
Can be
It may-
delinked.
So there are factual dispute, but that issue may be not delinked.
So by virtue of some order, it is.
Yes,
Yes, my lord.
yes, it was
Tagged by-
before honorable
tagged.
single judge, my lord, it was pending before honorable single. In fact, my lord, there were other 25 petitions which were pending before the honorable single judge.
No, this is posted along with PI by virtue of some order.
Yes, my lord.
Please, my lord.
Which order? Whose
Only
order?
the interim order, my lord, the date, my lord, I am not part. However, my lord, the main petition, so motor petition.
My lord, the order was passed in the PIL, my lord.
In my-
30th January.
670
30th January order. All these matters, 6 matters were listed along with it.
At-
30th
But
January.
it is upon the suggestion of the amicus curiae, Advocate General.
Yes, 676 of 2024, my lord. In that, I had made a request only to ensure that, my lord, the amount is, my lord, dispersed, not with any other adjudication purposes, my lord. Only to ensure that victims get the compensation. And in other batches also, lordships will recollect.
While hearing the main matter, that not now.
Some date could be fixed, my lords.
When shall we keep? 2nd July?
First week of July, yes.
Second.
Second.
Grateful.
Grateful, my lords.
And we have filed our reply as well.
Please, my lord, we have
Request a
also filed.
copy
a
be,
reply.
copies be served.
Sure.
Yeah, grateful.
They can file a response to that in the meanwhile, my lord, they can look at what we have.
All pleadings
filed.
be completed before the matter is taken up for trial.
We'll
It is
file
there
it.
yet.
Good.
You want to file something, then file it.
Please.
Two 30 matters, seal number 69 for withdrawal.
My lord, I appear for petitioners in this case. My lord, I have filed a memo seeking withdrawal of, my lord, writ petition itself.
In view of the,
I may be permitted to, my lord, withdraw the writ petition on behalf of all the petitioners, my lord.
where is the memo? Vijay?
I have instructions to withdraw the writ petition itself.
Learned advocate for the petitioner appears online to point out to the court that
Monday manage madalta.
memo dated 19/4/24, in which it is stated that the repeated petition can be filed under misconception of facts, and that therefore the petitioners are not interested in prosecuting the petition. Request is made to permit withdrawal of the petition. The request in the memo was repeated by learned advocate in course of the submission. Permission is granted to withdraw the petition in view of the above memo, dismissed as withdrawn.
Seal number 70.
Petition is dismissed as withdrawn.
So, okay, Muralidhar.
Appear for the respondents in this matter,
Serial
my
number?
lord.
Yes, why it is that 230?
Lord, the government advocate was directed to furnish the proof of payment of compensation. Just now, she gave me a copy to say that they have deposited compensation in August 2023 before the civil court. May I request for a week's time to verify?
This was yesterday, 27.
Verify and.
My lord, I just received this from the file of the Special Land Acquisition Officer.
Just now, she provided me this copy. I will
My lord,
verify.
with regard to one execution petition, my lord, there is no information that I will verify and I'll make my submission. my lord. Lord, I apologize for just giving it like that, my lord.
So land was acquired for defense purpose
Yes.
and according to them not utilized. Therefore they want back.
My lord, according to them, the land is not utilized for the purpose for which it was acquired.
Therefore they want back.
No, there's a direction to pay them compensation. They asked for enhanced compensation, my lord. The compensation was enhanced and thereafter it is again reduced, my lord, before the Lok Adalat. My lord, pursuant to which, my lord, now there were execution proceedings also filed.
Yes, yes, we recollect.
My lord, let my learned friend verify and my lord get back, then we will know how much money.
Yes, my lords, I will definitely verify and get back to my lords by next week. my lords. Because they have deposited this in civil court.
This is balance amount.
Balance amount
Yes, my
according to
lord, the
them.
enhanced amount. that had to be.
Pursuant to local Adalat.
Yes, yes.
Pursuant to Lok Adalat order, execution is
Those
filed.
are the
And
instructions that
they are
received
now
from-
claiming that they paid the compensation in August 23.
These are the instructions I have received from the Office of the Special Land Acquisition Officer.
And we'll take it.
I will get back to my lords in next week. my lord.
Next week.
Next.
11th.
Pardon, my lords.
11th will do.
Yes.
11/6.
Obliged, my lord.
Now that the admitted facts are, my lords, the land was taken invoking section 17. The land is not utilized. Before taking possession, 75% is not deposited. Compensation is not paid as per the Lok Adalat order. Indoor Development Authority case may apply. Obliged.
This is number 17. With Mohan Kumar D.
Complement in this case. no?
Compliance has been done, my lords, but it is not filed. Complaint will be disposed.
Disposal, there is an addendum on part of both the learned advocates, on part of rewrite it. Learned advocates to this so and so, but the complainant could not dispute the statement made by learned additional government advocate, Ms. So and so, that the order under contempt is complied with. In that view, this contempt petition does not survive. Since the directions are complied with, accordingly it is disposed of.
So number 18. Sudhindra is here.
Petitioner appointed
Please take this.
as a teacher in Grantinate School. Then in 1988, her job has been approved for 1998.
The affidavit is ready, my lords.
2016.
You have given some order.
You have given, sir.
Before arguing, you look at that order.
2006 has been considered as a.
First you see the what is given by your learned friend, then argue. So you might not have to argue.
Last occasion, they have given some endorsement, right? It is not considered. My prayer is to give the placement. after relieving from the
Whatever,
BBMP,
we are concerned with the direction, not your prayer. Whatever directed to consider.
they are not complained.
Representation. Consider the representation of the petition dated 9th March 23 in accordance with. They have done accordance.
No, my lord.
And
Yeah,
propose it
An-
to the
Annexure,
council in
annexure,
accordance with.
annexure you, my representation submitted to give the placement to continue after relieving from the
Given or not
BBMP.
given? Endorsement, how is fine.
Annexure you, my lord. Petition.
Yeah, लिखा है. What is written?
Lords, the representation given by the
You are
complainant.
sending him pillar to post.
My lords, may I submit this? She had given voluntary retirement for representation to consider her voluntary retirement, which was considered, my lords. But the accountant general did not approve it because she had not completed 15
He
years.
wants the application of voluntary.
Lords, she is a private institution teacher, and the appointment has to be done by the private
He
institution.
wants his request for voluntary retirement to be considered.
No, my lords, he wants the reinstatement to be considered after almost 12 years.
He is backing out from voluntary retirement.
He's been relieved from the private institution. She was appointed in 85 and admitted to granting aid in 95. Thereafter, my lords, she was relieved from the private institution, went to BBMP school to work there. Thereafter, my lords, she gave a voluntary retirement representation. The BO approves it and sends it to the accountant general. But since she had not completed
Now
15
this
years
page 10 endorsement is passed by which authority?
by the Deputy Director of Public Instructions, she had given a representation. To consider representation, we have issued this endorsement stating that the proposal has to come from the private institution because the authority to appoint and disciplinary authority, it's the institution itself. So she cannot directly give the proposal to the Deputy Director because this is a grant in aid post, my lords, from a private institution.
My lord, when she was appointed in 1998, the post was approved. Then the second respondent commissioner considered as an excess teacher, my lord. So on that basis, the commissioner has deputed to the BBMP school, that grant in aid school. Then that BBMP has been relieved her. Then after relieving from her duty, the duty of the respondents to show the placement, because she already considered the excess teacher in granting at parental school, my lord. Copies of the repetition.
So whom shall we who shall consider the representation?
Lords, she had to go back and report back to the private institution, which she has not done. So therefore, it is the proposal which has to be sent by the private institution who is a party in the writ petition. 9th respondent.
My lord, when she has been relieved from the BBMP and granted a school, the duty of the respondent's authority to issue an order to report at a parental school. Parental school in that institution, there was no vacancy because she already considered the excess teacher. The respondent authority second and the respondent number 6 has to show the place to work in other place, other granted school. But they have not did it.
You wrongly deleted number 9 in the repetition. Because it is number 9 which will be considering.
Please.
The request.
My lord, there is a direction. Respondent number 6 has to give the direction to the respondent number 9, my lord, in the WP. Because already when she was declared as an excess teacher, she is not supposed to report in that parental school, respondent number 9 school in WP. So WP.
My lords, respondent number 9 had to give a proposal to us to take her back and report her back, which they have not.
Proposal. Why this?
Because she is the appointing authority is respondent number 9, disciplinary authority is respondent number 9. It is a private institution.
Decided to be decided by whom? Decided by whom?
That proposal has to be, once the proposal we receive,
You decide.
then we
You
receive.
call for the proposal. If you are the decision-making authority. You are under direction of the court. Then you undertake the procedure. Don't send him pillar to post.
Lords, after 12 years, my lords, now for compulsory retirement was already accepted and forwarded.
Understand that you are not the proper authority. You have to solicit some information or proposal from somebody else, some other office. Then do it because you are under direction. Why can't you do it?
Very well, my lords, I will.
To do it, take in sense.
Please.
Activate
This-
your authority after
This
4 weeks.
2011, my lord, they are keeping the file with the respondent office itself. They are not passed any order, no direction to report in some other schools, my lord.
Then why did you delete number 9 at the time of petition?
Let them also be made party. my lords.
Because she first, beginning she has appointed in respondent number 9, my lord. So when she has considered, respondent 2 has considered as the excess teacher, she has been relieved from that institution. But there is no vacancy. There is no vacancy in a parental school.
The stand taken by respondent 6 in his compliance affidavit that it is respondent 9. It shall be the competent authority to look into the representation and decide the same as directed by learned single judge from a learned additional government advocate, Ms.
Pramodini Kishan.
Pramodini Kishan. Submitted that respondent number 9 who was initially party but deleted, needs to be joined so that respondent 6 can take up the issue with respondent 9 to comply with the direction. Full stop. Respondent 9 shall be re-added as party in the area of respondents. Full stop. Notice of this contempt petition shall go to the newly to the said respondent 9. Full stop. Put up on 16th of July. In the meantime, learned additional advocate general, learned additional advocate, government advocate shall coordinate with number 9 and take necessary process to comply with the directions.
My compliance affidavit, which has been filed, may be taken on record.
We file objections.
In the beginning, the compliance was taken on record.
We file objections.
This is number 19. So Badri Visa.
All of the single judge, my lords, that page number 14, my lords, is not complied with.
Number?
14, my lords. Last para in page 14. In view of the above, the repetition succeeds. A writ of certiorari issues
occupancy of land.
Occupancy rights. Within 6 months, it had to be done, my lords. On 18.
Lords, the land tribunal is not yet constituted because of change of government. Will not.
My lords, the order is passed, my lords, on 28/11/2022.
Committee is not constituted. Committee is not constituted.
Land tribunal is not being constituted.
Land tribunal is not.
Tribunal.
Lords, the order is passed, my lords, with page
When it
number
is
11,
likely
my
to
lords.
Lords, I'll submit with
It's been
instructions.
1.5 years, my lord, since the order has been passed. There's no action taken, my lords. They've given 3 representations. Lordship may see page number 16, my lords, 16, 17, 18. The order is of the year 2022, my lords.
So this land tribunal is constituted under which law? Under which law? Karnataka Land Reforms Act.
Land Reforms Act.
Constitute, who will constitute it?
No, it's the government has to constitute, my lords. Once there's a change of government, then the government has to constitute.
Lords, the state was a
The number of cases must have been pending.
Most of the
Be
districts
considered
it's
by the
been,
land revenue.
very few districts it's not been constituted, my lords. Most of the district have been,
The district level.
yes.
Check and we'll find out why it's not constituted.
We put up after 4 weeks.
As
In the
All
meantime,
the litigation must have come to a standstill in that, we'll verify.
My only request, my lords, shorter, 2 weeks time, not because it's a 2022 order, my lord.
4 weeks, 4 weeks.
So let it come after 2-3 weeks, we'll see what's the progress. We'll try and do it at the day.
they are going to sleep and take rest after 4th. So let him have time for 4 weeks.
But it's with the matters of the year 1970, 65, my lords.
We understand, but this is an issue which is to be matter of policy decision. So let them find out when they can constitute. First of, today is what? 1st of July.
Please.
And additional advocate, additional government advocate will take instructions about the constitution of the land tribunal, which is to comply with the direction of law on a single judge brought under this contempt jurisdiction.
Number 20, Mr. Keshav Bhatia.
We'll file our compliance within a week's time, my lords. It's
Within a week. 24th June.
Merit?
Early.
No, no.
24th June.
For 21, to Shiv Shankar C. For 21,
Not there. After 4 weeks.
so 22 urgent, number 23.
No, 22 is not it. You have said no. You was required, let us. It was not refused. Give. Go on. When it is. We have said no to adjournment, to ask that judiciary to remain with anyway. 11 July.
Number 23, Mr. Rajeshwar PN. For the land funds.
Yes.
Against the cancellation of the allotment, the petitioner had filed a writ petition which came to be dismissed, against which the writ appeal has been filed. The total extent of land was 163 acres. Pursuant to the cancellation, we are given allotted the same land to 3 other people. Now, what we are trying to, if it is possible, trying to see that the petitioner and the other allottees also, with regard to this 168, whether everybody can be accommodated in order to give a quietus to the issue.
Where is the?
Learned single judge's order is at page number, 44, page 44.
It's 65.
So what is it about?
Well, this is the case where 160, initially 163 acres was allotted to the appellant. Manoj. Subsequently, he gives a representation saying that I don't want 163, allot 50 acres of land.
50 what? You want 50?
50 acres of land. Manoj. Subsequently, Manoj, the question is, then he says that what price this should be allotted to him. So that is why, Madam, we have cancelled this allotment since we have not allotted the 50 acres of land also, against which he went before the learned single judge. Out of that 163 acres, Madam, 50 acres is what was his cases. There are three other companies that balance 13 acres, Madam. It's given to three other companies called JDV Holding, Mysore Logistics, and Zeal Tech.
So who is for the original petitioner?
I am for the original petitioner.
I appear for the Udyog
My
Mitra.
learned friend appears for the original
I
petition.
appear for the original petitioner, my lords.
And the appeal is by you?
No,
By
by
us,
them.
my lords. By us.
By them.
As
The petition came to be dismissed at page 65.
Yes.
As the Advocate General suggested, my lords, they have called us for a meeting, my lords, so that we can work out an amicable solution.
So you only want 50 acres only?
My
That's
lords,
what if you
my
restrict-
case before the learned single judge was 50 acres at single unit complex rate, my lords, not allotment rate. So that's the dispute, my lords, now.
So that is the only dispute now?
That's the only dispute which is burning down to Manoj. So therefore, Manoj, we have called all the four companies, Manoj, so that they can sort out the issues and we can allot it to all four companies, not only to the appellant. Manoj. So therefore, Manoj, after 2 weeks or 3 weeks, probably we'll give a quietus to the litigation.
3 weeks,
3
12th
weeks.
of July.
Interim order may kindly be extended. Lord. Interim order may kindly be extended.
Send out to 12th of July. Shall we record that?
Not required, Manoj.
Send out 12th July. 10th July.
Please.
Interim order already operative shall continue to operate till the next.
24, 25 are urgent. Seal number 26, Mr. Chandrakant R. Patel.
The appeal for the respondent. I'm for the appellant, my lord. May I kindly pass over, my lord. Senior is-
Passover will not be possible. Some other day after 4 weeks.
Interim order. my lord. Interim order. my lord.
9th July.
Twenty-seven urgent. Seal number 28.
I'm appearing for the complainant, my lord.
Yes.
Last time there was an order for Deputy Commissioner of Public Instruction to submit a report regarding the child's admission. The minor child is with the grandparents, and still now he was not admitted to school. Therefore, there was an order by 27/11 by this honorable court to get the child admitted to a school called ICANN school. So since there was no admission and there was no information to the parents, we have moved this memo for advance hearing during the vacation.
One humble submission in this matter, Your Lordship.
Your Lordship, here the school has granted the admission. Email has been sent to all concerned. Your Lordship may have the email and other things, if Your Lordship permits.
Just one note, I will submit because the government was directed. Government was directed to get the information. The government has been directed to get the
Yes,
information.
what is happening to writ petition? What is happening to, which order is under challenge?
They have challenged, in fact, an order passed in the writ petition where the visitations were to continue. Now,
in this appeal, which is the order under challenge?
If I may submit in this matter, Your Lordship.
The order is dated 27/11 of this honorable court. Because they were not complying with the orders of visitation, we had moved this contempt petition.
Which order is under challenge in this writ appeal?
Writ petition 8425 in this order, 19th August 2020. 2022 is under challenge.
At which page?
That order is at which page?
Yes, my lord.
If your lordship may kindly have page 11 of the contempt petition. Page 11 of the contempt petition.
11. Yes.
It is 21st of April, 2022. Your lordship, may I read it? It is 21st of April, 2022 in writ petition number 8425 of 2021. Your lordship has it?
11 is part of your memorandum.
Lordship, contempt has been filed by the petitioner. I'm just trying to assist this honorable court as to which order the contempt has come from.
Yes,
The 16.
madam, which is the order under
Page
challenge?
number 16, my lords.
Page?
Page number 16 of the contempt petition.
16 is interim order. So what is the difficulty with this order?
My lord, subsequently, they were not complying with the orders and we had moved this contempt petition. In this order, this honorable, they were contending the child was having psychological problem. And in this order, by order dated 4/11/2023, this honorable court has directed to get the child admitted to Nimham's hospital for treatment. In that, it was found that the doctors have submitted a report stating that the child is normal. And therefore, this honorable court by its order dated 27/11.
You are for mother.
Mother and father. Parents.
No, you are for parents.
Yes, madam.
So who is opposing you?
Grandparents are the respondents who is having the child with them. They are not sending the child to school. That is why it was reported by this order, by this honorable court's order, they were asked to send the child to the school. And they have not got the admission. So we have moved a memo in this because it was posted on 19th actually. During the vacation, we have moved a memo for advance hearing. Child is 9 years old. Still he was not admitted to school. That is the reason we have.
Your lordship, if I may be permitted to assist slightly, your lordship may kindly have the order dated 5th of October 2023. Now, this is a detailed order which has been passed by the honorable court with regard to welfare of the child. In this order, your lordship will observe the child was sent to Nimham's for a month, and the detailed observation.
My lord, it's 15 days, not for a month.
The child was sent to Nimham's, and detailed observations were made by, and those reports have been filed before this honorable court. It has come to the light that the child has to be given psychotropic drugs in order to keep himself calm. The child, minor. The Nimham's has prescribed the drugs. Even earlier, the psychiatrist have prescribed the drugs to the child to maintain his calmness. He has anxiety disorder.
You are for who?
I'm for the grandfather and grandmother and the sister. And there are two cross
In the
suits filed
contempt
in the.
petition, his sister is not appearing, my lord. He is misleading this honorable court by giving the doctor has submitted a report. A panel of 5 doctors had been before this honorable court and had submitted a report stating that the child is normal, my lord.
Your maternal grandmother.
And the custody has been granted to the grandfather.
Custody is not granted, my lord.
Interim custody is.
Interim custody is not granted. They were having the custody. We had filed the petition for custody. There was no where interim custody is granted to the grandparents. My lord, I am not able to hear.
Between the, you come here and assist the court. If you are
Yes,
capable.
yes, my lord. On the next date of hearing, I will appear, madam.
Pardon?
On the next date of hearing, I will be.
Next day, you kindly do that so that we may be better assisted. So when shall we keep? 2nd July will keep?
Your lordship, 2nd July is
2nd July.
2nd July. Deeply obliged.
One humble submission, your lordship. One humble submission on behalf of the government in this matter, your lordship. This matter, yes, ma'am. This matter was moved in the vacation bench by the complainant, your lordship, alleging that the contempt to the extent that the child has not been admitted to the school. The mother, who is the complainant here, they have not given the main crux of the matter why this contempt has come before this court. The allegation of the complainant is that the grandparents who are having the interim custody right now, they are not sending the child to the school, so child is losing out on the education.
Parents are not sending.
No, the child is with the grandparents, maternal grandparents.
Child is grandparent. Child is
Yes,
with you.
child, that's the
Child
main,
is with the
the
grandparents.
main.
What is the age? Boy or girl?
Boy.
What is the age?
9 years.
9 years.
And the child has been with us since he was 2 years of age.
No, that apart, madam, that's for the merits of the case because there are 2 guardian watch.
Wants to be with you or with?
With the grandparents.
How do you say so?
Lord, the trial is pending before the court. So I think the list there.
Your Lordship, the list here is that the child is not going to school. ಹೌದು. School ಕಳಿಸ್ತಾನೆ.
Your Lordship would like to interact with the child, I can ask the child to come on next date of hearing.
Or let when you mean.
Your Lordship, we can call the child on the next date of hearing as your Lordship has given it. I will call the child and possibly a time may be fixed because what has happened, he has gotten very scared of the court premise. He's very scared of the ushers and people around. He feels them. So I would.
Any psychological?
Yes, yes.
What?
There is a report by the Nimhans. He's on psychotropic drugs to keep him calm. Somehow the parents are not willing to accept it.
Been given the.
Yes, yes. He is being administered psychotropic drugs for last more than a year now. More than a year.
My lord, only for after the permission. First, there was a report from All India Institute of Medicine.
You've gone for mediation.
All those things have happened. The cross-suit is filed between the own father and the daughter. Unfortunate case, but somehow they are not able to see things because the daughter summoned the police. The daughter then got the things. So things have become. And she has been filing. This is not the first contempt. This is possibly the third contempt which she has filed against the father.
Because they were not
So
complying
once-
with the orders of this honorable court.
Once your client,
They are here, your Lordship.
maternal.
Grandfather and grandmother.
Grandparents.
And the parents, stop fighting. There
Things
will
will-
no drug will be necessary.
Absolutely, 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 your Lordship. Absolutely.
So then don't.
I have tried. I've tried my level best, Lordship. In fact, this matter has been taken up in chambers by the previous honorable
It's
courts
unheard
also.
of that the parents and the grandparents spoiling the future of the child. fighting.
Unfortunately, your Lordship, I would definitely say this. Your Lordship may kindly meet the child to see because we are having arguments and counter arguments. The reality is the child. If your Lordship once meets the child, the things will be at rest. And the child has been summoned to this court even earlier by the single judge, by the division bench.
So let the parties remain present.
My party is here. They come regularly. Your Lordship may ask them to be present because somehow, even for the school admission, they are not there to give the interview.
We have gone for the school admission. Just may not be may not mislead the court by this honorable court.
You are for parents.
We are for parents.
So child is with you.
No. Child is with.
Child is with the grandparents, my lord.
So then you said that you had gone for admission purpose.
We had gone to the school, but school had summoned, and we had gone to the school.
On this point, Your
Without
Lordship,
the child.
on last
Without
date of
the child.
hearing, when the matter came up before the vacation bench,
What is the real dispute? What is the real dispute?
The dispute is the child wants to stay with the sister of the mother and the grandparents because he is extremely attached to all three of them. And he's scared of being snatched away. That is the real dispute. And somehow the mother, instead of trying to cooperate and understand the child, she's trying to snatch the child away. And that is what the child is feeling.
When your client will remain present, madam?
Then on the next date of hearing, my lord, both of our clients will
Tell the
remain.
date and we'll try to find out some solution if we can at all.
Yes, any date next week, my lord.
Third we'll do, next week, 25th
Yes,
of
ma'am.
June.
Lordship may
Yes,
have it
madam.
the date fixed. The 2nd July was appropriate. May fix it around afternoon or whatever. The
2nd
child will
July,
come here.
2nd July.
2nd July afternoon, post lunch. Your Lordship may give just 15 minutes in the chamber with the child.
We'll consider where to take up.
Right.
2nd July.
Right. 2nd July. Deeply obliged.
Much obliged.
Number 29.
No, 29, my lords. I pray for 2 weeks' time, my lords. My lords, sir, kindly please to direct me to produce some information, my lord. Since, my lords, the elections are going on, my lord, I have not been able to get the information. I pray for 2 weeks' time, please, my lord.
My lord, about 1 lakh people, families are waiting for last 5 years, my lord. 1 lakh families are waiting for refund of their investment for last 5 years, my lord.
Who is waiting? 1 lakh people?
1 lakh investors, my lord. There are 18 companies which have swindled money, my lord.
My lords, I'll give the information, my lords. I only pray for 2 weeks' time, my lords. In view of the elections, my lord, my officers have not been able to give me the information.
In one or two respondents, my lord, they have not
So-
even called for claim forms for last 5 years, my lord.
The report is we direct the competent authorities to process the claims within 3 months. So what is the position of compliance, Mr. Counsel?
My lords, I prefer 2 weeks time, my lords. In certain matters, my lord, we have indeed, my lords, auctioned the properties in 1 or 2 matters, my lord. Certain
Last time
matters are
also-
before your lordships.
Since last 2 time you are asking for time.
Last, my lords, last time, my lords, your lordships are kindly please to direct, my lord. Since my elections are going on, my lords, I have had a difficulty. I pray for 2 weeks time, my lords. I'll file the entire details before your lordships, my lord.
Any compliance affidavit is filed today?
But today is not filed, my lords. I pray for 2 weeks time, my lords.
My lord, they were
Because
directed.
the
to
officers,
the-
my lords, are busy in the election, my lords. And by 6th, my lords, even the MLC elections will be done, my lords. So I'll pray for 2 weeks time, my lords. In a tabular form, my lords, I'll give all the details, my lords, that we have, my lords.
Learned counsel prays for time, stating that he could not obtain the instructions. Full stop. No further time could be granted in the section surveillance case from except up to 1st July. Stand over to 1st July.
My lord,
It is
on connected matter, my lord.
It is observed that any further, no further time will be granted on that.
My lord, one connected matter, WP 514, my lord, I have already filed in contempt for the not complying with the order. They have not given any action taken report last 2 years, my lord.
So that is what they want to file.
No, my lord, that's another case, my lord. This is one case, that is another PIL, my lord. That is for the similar company, Canva, another 20,000 depositors have 2 years, they have not submitted any
For some
action
reason, the
taken.
council wants time, we don't know for what reason. For
My
filing
lord,
some-
they may be directed to submit action taken report in that case also, my
It
lord.
is already directed earlier.
The other case, that is, this is 19.4, my lord.
It is already directed.
Connected matter, my lord.
There is already an order, but we are not wrong. Schedule of auctioning the property. Same.
Action taken report for WP 514, my lord.
For that only they will be appearing to apprise the court about the action taken. First.
CC number 30. So Tyagarajas, yes.
Here for complainant in this case. The court was dismissed in non-compliance for all.
Serial number?
So 30.
Kindly recall the application. Office is raised 7 objections. I will comply for it. I comply 1 week.
You are for whom? You are for applicant or respondent?
The complainant. Complainant.
I
Petition is
complain.
dismissed for non
Complainant. You want time? 9th July. Stand over to 9th July at the request of learned reviewer for the complainant.
CC number 31. K. Mallikarjunaya.
Or the order of the last single judge has been complied, madam.
Still complied and compliance affidavit has been filed.
Affidavit is sent. It is complied with?
Complied with the order. It has been complied with.
Complied with.
Complied and affidavit also has
Learned
been.
learned additional advocate for learned additional government of states that the directions under the directions of learned single judge and complied with. From a learned advocate for the complainant could not dispute the statement. He concurs that the directions are complied.
Even my lord, respond number 2 also filed, my lord, the complaints affidavit. Even respond number 2 also.
Complied with or not complied?
Complied, madam.
Complied. Full stop. He concurs with the statement that the directions are complied with. In that view, paragraph, nothing survives in the contempt proceedings as the orders are complied with as per the statement made by learned advocate parties. This contempt application is disposed of as not survived.
CC number 32. Mr. Raghunath, MD.
I appear for the complainants, my lord.
I appear for the respondent 3 to 5. I am ready with the reply affidavit, so. I'll file it during course of time.
Humble submission, my lords.
I have served the copy of the,
I've received it.
and I have filed the wakalat for R5 in morning session, Your Lordship.
This contempt, my lords, is arising out of a single judge order, my lords, which my lords may kindly peruse at annexure A at ink page number 11. Paragraph number 5, my lords.
I
It-
may-
On
Please.
5 Yeah,
I may
read-
permit it to.
Read it.
Please, my lords. It says, in the view of the matter, the permission for carrying out the interior works is refused since action has already been initiated by the corporation under the section 248 of the BBMP Act and an appeal is still pending. The decision of the chief commissioner would be binding on the parties. But unfortunately, my lords, the accused have already started the constructions and also the interior works have been done, which my lords may kindly peruse at annexure B, ink page number 13, my lords. These are the photographs which have been produced before this honorable court, showcasing the works being done by the accused number 3 to 5. In fact, based on these photographs, the complainant had actually filed a representation before the chief commissioner as well as the assistant executive engineer, my lords, which my lords may kindly peruse at annexure C at ink page number 16.
Yes, what do you?
I'm ready with the reply. I'm submitting.
What is the reply?
And appeal filed by the respondent 2, 3 and 4 has been allowed. The matter has been referred back to the authority for reconsideration.
Give copy, then will
I
not-
just received the copy now, my
Nothing
lords.
will survive. How?
My lords, I just received the copies. My lords may kindly have it in a week's time. I shall
No,
go
no,
through.
why? If there is an order of the appellate court remanding back, nothing will survive.
And what the photographs produced by the complainant has not belonged to me. Respondent 3 to 5. It is belongs to some,
We can keep day after tomorrow.
Please, my lords.
Day after.
Day after tomorrow, it may be put.
At 2:30. Learned derogatory, the respondent says that the submits on the basis of the compliance affidavit that the directions that the order brought under contempt was subjected to writ appeal, which was allowed and the case is remanded. Full stop. Learned derogatory, the applicant 6 times to verify the statement. Stand over to 5th of June.
Please, my lords. Much obliged.
To be listed at 2:30.
Number 33, Mr. B.K. Chandrasekhar.
this matter compliance has been done.
Learned additional government advocate makes a statement, advocate Ms. Pramodini Kishan makes a statement that the order under contempt is complied with. He files compliance affidavit. This is taken on record. Learned advocate for the complainant could not dispute the factum of compliance. In that view, nothing survives in the present contempt proceeding. They are disposed of accordingly.
Number 34, Mr. H.M. Muralidhar.
Accused, my lords. We were directed
For
to
petitioner in this case, my lord.
file a memo along with the result declared document, my lords.
Small submission, my lord. I am appearing for the petitioner. Respondents are complied with the order. Kindly close the contempt.
Kindly,
Close the contempt.
There's an order, my lords, for the university to allow the student to appear.
the complainant says that close the contempt.
Please, my lords. We have complied it, my lords.
Learned advocate Ms.
Petitioner, for the petitioner, Malini.
So and so stated that the directions of learned single judge in order dated 30th January 24 passed in writ petition number 26730 of 23 have been complied with. He further states that any of the compliance, nothing survives in the present application and that the contempt proceedings are required to be disposed of. Since the order is complied with, paragraph, nothing survives. Since the order is complied with, as per the statement made, before the court, nothing survives in the present proceedings, they are closed. Notice is discharged.
Please.
So 35 urgent, number 36. Venkateshappa.
Memo has been filed for withdrawals. Memo has been filed to withdraw this contempt. That order has been complied by the respondent.
It's an interim order, my lords. However, it has been complied with respect to transfer. Lords, the respondents have been have reported back to their original place. So there is compliance by the accused.
Now withdraw. The withdrawal memo dated 24/4/24 is filed by learner of the complainant, which figures on record, in which it is stated inter alia that is 1/4 has complied with the order of the court brought under the contempt jurisdiction by relieving the accused number 6 and 7, relieving the respondents 6 and 7 from Nandi Medical College and Research Institute, Chikaballapura, as per order stated 22/4/24. In that view, it is submitted that the complainant may be permitted to withdraw the contempt petition. Also, contempt petition is going to be withdrawn in view of the memo as aforesaid filed by the complainants. Nothing further is to be considered in this proceedings, which are disposed.
So 37 urgent, number 38.
But this matter, I'm appearing for the impleading applicant.
No, 38 separate. 38. Sorry. Like order annexure A challenge. Like referring the.
My impleading application is pending, Lord, and
Like his application was considered by the secretary and rejected it, Milad, saying that they have no locus. That only small issue remains, Milad. Now this order annexure A, Milad, has been complied with by the FSL, Milad. This assistant commissioner, Milad, has sent the report of the assistant commissioner, whether it was a signature of the earlier assistant commissioner or not. Milad, the FSL report has come, Milad, and therefore only what is remains to be is, Milad, a direction to the respondent 1 to 3 to consider the notification issued by the state government. Milad.
What is your stand, Mr.? For release, if it is liable to be granted. One report appears to be favorable, subsequent is not favorable.
There are two files maintained, Lord, with respect to joint inspection. If it is a Gomal land, there is a requirement that, Lord, a joint inspection has to be conducted by assistant commissioner and the jurisdictional senior geologist. Lord, then only the requirement of 8BD1 would be complied with as per 12/8/2016 amendment. The contention was that, Lord, there was no joint inspection in order to say that this is a saved application. Therefore, Lord, the joint inspection was sent to the forensic science laboratory for testing the genuineness of the joint inspection. Now it appears, Lord, that there is a report submitted by forensic science laboratory. Now it is for the authority to consider.
Direct them to consider the application with some time frame, Milad. That only survives your lordships in this case.
Because
the
so far as
FSL
first
report says,
prayer
Milad,
is concerned, it become infructuous in view of the forensic science report, laboratories report.
Prayer C only survives, my lord.
Yes.
First prayer means 7/7/22. No.
B and C not survive for consideration. Only C, prayer C, page number 25.
Only prayer C will survive.
Yes.
Direct number 1 to 3 to grant co-release on the basis of the report of the deputy commissioner.
No, just for consideration, it may be directed.
Consider in accordance with law will be enough.
Yes.
My submission.
Not on the basis of the deputy commissioner.
That a notification was issued inviting applications for grant of quarry lease. That pursuant to that, this application filed, my lord. At that time, Rule 8B was there, my lord, where they invited application because it's a held area, akin to Rule 59 of mineral concession rules. Pursuant to that, my lord, the application was filed. My lord, it was rejected, my lord, the petitioner approached this court directed you approach the revisional authority. My lord, revisional authority has set aside and restored the application. And the application is pending consideration, my lord. The opinions were sought, my lord. The deputy commissioner doubted the signature of one of the serving officer of the assistant commissioner, stating that it may be a forged document. It may not be the signature of the assistant commissioner. Then, my lord, it is referred to the forensic lab to ascertain whether it is the signature of the very same assistant commissioner which one of the reports submitted. Now, the forensic report submitted, my lord, is the same signature. Therefore, my lord, prayer 1 and B will not arise. Only thing is, my lord, that consider the application annexure B in accordance, C, my lord, in accordance with some time frame will be my humble submission to the court.
Can we done?
Within, yeah, will.
Is this report at page 35? It is favorable to petition. Page 35. Page 35.
Based on this complaint only, my lord.
So this is report or what?
This is
the complaint given by me, my lord. I'm the impleading
you?
applicant. Yeah, I'm the impleading applicant, my lord, in this case.
Venkataramanappa has filed a complaint.
So where is the application?
Inspection report is annexure G, page
Application is
65.
at annexure C.
Annexure C.
Page number 47.
This is to be considered.
This
is to be considered.
In accordance.
In accordance with.
In accordance.
Some time frame.
Lord, my application, my lord, this is a Gomar land, my lord. We are the villagers. We are the
They
one.
will decide within how many? 3 months. 3 months.
5 months at least, Lord, because
4 months.
Please.
Number 38.
This is number 39. HR Shori.
Madam Lords, the last date, Lordships have noted the objections filed by respond number 5. They have undertaken that there is an encroachment and they will remove it, my lords. Matter is adjourned to today only for them to confirm in how much time they would do it, my lords. Is the last date of hearing.
My lord, appearing
For
for,
that issue, they have sought instruction. They took time, my lords.
my lord, appearing for respondent number 5.
Online.
My lord.
Yes, madam, what did you do after last date?
My lord, the municipality has
Only thing
agreed
you
to do the,
Only thing you did is that you have disappeared from physical appearance and entered in the TV screen. What
my
did-
apologies.
What steps did you do? Did you
My
take?
lord, they'll take, within 8 weeks, they'll comply, they'll take necessary actions, my lord.
You're not able to catch what are you submitting?
My lord,
Any action is taken for removal of encroachment?
my lord, they'll take within 8 weeks to do the necessary actions, my lord.
No, 8 weeks not. You bring your commissioner. Who is commissioner? Commissioner here. So last time also we gave you the leverage that you take instructions.
My lord, they'll comply with the necessary actions within 2 months, my lord.
Time may be given.
It
2
is
months.
What kind of encroachment?
My lords, in the government land, my
Land.
lords, some the
36.
adjacent, now it seems that there are two kinds of encroachment, my lords. If lordship may see the survey report, my lords, that they have seen, the my lords, only 36 guntas of land found to be encroached. my lords.
524 following order was passed by the court. And court the entire order. When the petition comes up for consideration today, learned advocate Miss Parathi
Yes,
for
my
this
lord.
one appears through online mode to submit that that respondent 5 will remove the
Yes, my lord.
encroachment
Yes, my lord.
within 8 weeks.
Yes, my lord.
In 8 weeks.
Yes, my lord.
Also, the said statement is recorded. Paragraph, learned advocate Mr. So and so for the complainant is satisfied with the statement, expecting that the commissioner would act as per the statement. So to be listed on 16th of July, 19th of July,
Much.
on which date learned advocate for zone 5 shall apprise the court about the progress of the
Much.
process of removal of the encroachment.
Much.
This is number 40, Mr. M. Shivprakash.
Like to the respondent number 2 and 3. The address given in the notification is the same thing. I have taken service to the respondent 2 and they are saying that it has not been served. They have changed the address from Hebbal to other place. I may be given permission to take further steps and to serve a notice on 2 months. 2 is the project director. 3 is National Highway Authorities.
So this kind of directions are executive functions of the executive. We have taken a view that laying road and changing the layout is not the function of the court.
My lord?
It is not the function of the court. These prayers cannot be granted. This is PIL, not in.
It's
cannot be granted.
My lord, minute, 1 minute.
Road, laying of road and planning the road.
No, planning the road, not obstructing the road. What was the original plan they have?
Detailed judgment.
May I make a submission? The original project and original plan they have published. After publication of this original road and the project, they have changed and changed because of various reasons. Now the way in which they are now putting up this construction, yet to be put up the construction, it causes obstruction to 19 villages. 19, this is the only road where we have to come and access to the main road. And second thing is, Government of Karnataka has sanctioned and it is almost under completion, a hospital. Hospital is called Mother Child Hospital at the cost of 75 crores. They are almost in the completion stage. This is the only way and road for this Mother Child Hospital. And third thing is, this is the village where the highest production of milk in the entire state, number 2. The ingress and egress to this entire road, now the plan what they are doing is they are now obstructing and blocking. We are asking them to give an underpass or an alternative. Now, the minister concerned and the Honorable Union Minister also he has directed for a technical committee to inspect and take away a report. And the last week, that's in the last 27th of last month, my lord, the deputy commissioner and district authorities, they have conducted inspection and they have given report also. The traffic and also the movement of these persons in this road. That report has to be now considered by this national level authorities, then they have to take a decision. Because as a layman, we cannot also take a decision. A high power technical committee is appointed and they will take a decision. That's the report they have given to the villagers when they have approached the Honorable Minister. We made several representation.
Lordships, may I make one submission, minutes?
Way in which
I appear for Central Government, Union of India, minutes. Whenever these days, the express highways are constructed, the natural course of their communication normally gets little deviated or gets affected to some extent, minutes. Locally, each and every place, they will have their own issues coming up, minutes. Here, whatever is raised, the committee, they can discuss with the national NHA authorities. And if there is any modalities which can be worked out to resolve any such grievances, they can take a decision that may be considered by the NHA project director.
Well, that's what
happens is,
that's what high power technical committee is now sought for the suggestion. And the Honorable Minister for the Union Minister has and the representative given by the state government as well as the people of this 19 villages, the everyday movement of this village and also the important hospital of mother child investing about 75 crores. That will be totally obstructed. It's a 24 hours hospital, 24 into 7 and 365 into full year. Anytime, any day, it's a mother and child hospital. Now it is under completion. This is the only one road we have to go. Easy access we want. And also the villagers of 19 village, everyday movement of the vehicles is more than 1,000 vehicles, school children and the agriculture producers as well as other activities. Now we are not coming in the way of obstructing. We are asking that let there be one is the public purpose of this national highway. It's also most important. And the people of 19 villages is more than 25 to 30,000 people, everyday movement. That you please consider and look into it and let the high power committee suggest the ways and means to look into it and solve this issue. That's all my prayer with the authorities also. Now on the last Sunday, giving an appointment, the deputy commissioner of the Bangalore Rural District, he visited along with the project directors and he said, this cannot be until the technical committee gives a report. Then only you take up this project and then you proceed the report given. That's what the government can also secure the report and they can also place before the sample court.
Then remain satisfied with that.
My lord?
Remain satisfied with that.
No, demand satisfied. Now the demand.
To remain satisfied. We are not going to entertain this kind
My lord,
of.
I am not asking to interfere or to change the alignment or to do anything. My lord, this arbitrary decision, what was the original plan, original project? They have these project.
Same. It is reported also. Long judgment, 10 pages.
My lord, these project, that's a contractors, in order to save some money. These are things, shortcomings, they do it. Now we have brought it to the notice of the authorities as well as the Honorable Minister for this national highway. When it is before Honorable Minister for National Highway, a high power technical committee is to be constituted, and the technical committee will certainly will give a report. And even last week, when Deputy Commissioner, the district magistrate, when we visited along with his team, he has also given a report about obstruction caused and also the manner in which it causes total obstruction to the entire easement, the movement of these villagers.
It is an executive function. We are not dealing.
My lord, kindly, I can be convinced and I can demonstrate.
And about this hardship to villagers are all vague things.
No, it's not self-interested or only.
The part of development. We
My
are
lord,
not doing.
kindly hear me. It's not for a individual the relief, it is for public at large. And also the public interest of 19 villages is involved. It has got a broader scope and it has to be looked into. My lord, I'm not asking my lord to pass any order or direction. I'm asking and I'm requesting my lord, let the committee, which a technical committee has been now appointed, let them place the report. And if my lord is convinced about their report and their session, then my lord can take a decision.
What is your name? What is your
My lord, if my lord is proceeding for orders, may I kindly request my lord to give an accommodation so that I can place in such extraordinary, it is rarest of the rare case where this court can have a judicial review. The arbitrary decision taken by these authorities and these contractors, a shortcome. I can demonstrate it. I can demonstrate and I can convince my lord.
What?
About the interference of this court under such circumstances where arbitrary decisions and the way in which they cause to inconvenience to the public at large. I can place on record, my lord. I can place it on record.
Tomorrow, 11.
My lord, day after tomorrow, may I kindly request, my day after tomorrow.
Day after tomorrow.
Please, my lord, I am obliged.
We'll take up at 11.
Please, my lord. Obliged.
Number 41. LM Chidanandaya.
The petitioner was granted a license for the stone crusher unit, my lord, annexure F, page 45 is the license, my lord. Like annexure F license was granted.
Same matter which was there for years.
My lord, I'll say with due respect, my lord. Now, that is with regard to the quarrying activities, my lord, your lordships intended to stop where the blasting material used. My lord, there is a standalone crusher unit, my lord. We don't use any blasting materials, my lord. The building stone we bring, my lord, 20-25 kilometers away from the scheduled property.
Mr. Mahindra, where is the order which was passed in one of the matters?
May I give it to you?
Is identical. Almost.
Yes.
Subject to, of course.
Like in this
You are
case,
different than the
my
party.
lord, I will not take more than another 5 minutes, my lord. My lord, this license was cancelled. I approach your lordships, my lord. Your lordship granted an interim order.
Mr. Counsel, ultimately these all are in ultimate analysis, fact finding inquiry.
Your
which is better suited to be done for the committee.
Well, for the last 6 months, my lord, they have not undertaken any activity, my lord. These units, my lord, they will rust, my lord. And we will be, in fact, large, my lord, I can understand, my lord, so far as quarrying activity is concerned, my lord. Your lordships found, your lordships order also have produced in the connected CG Kumar matter, wherein your lordships, my lord, it is at page, kindly see, my lord, your lordships at page 112 for a minute, my lord. I am requesting your lordships to exercise the power which your lordships reserved while passing this interim order, my lord, last February. If any difficulty arises in giving effect to these interim orders, any person can move this court seeking appropriate orders. Similarly, after the study and research report is submitted to the statutory committee, it is open to the parties to petition move this court. My lord, in my respectful submission, my lord, your lordship is, my lord, we don't use any, my lord, this crusher is 15 kilometers away from KRS Dam, my lord. We only carry on crushing activities, my lord. Only building stone are brought, crushers are carried on, and therefore, my lord, affecting your lordship passed that order in the background that there was a report from some committees wherein, my lord, a sound was heard of quarrying activities by using the blasting materials. So in that background, your lordship, my lord, they have, my lord, my respectful submission, my lord, they have misused the word, the allied activities, my lord, and stopped. And in my case, my lord, I granted, this court granted an interim order that was challenged before the Honorable Supreme Court. Supreme Court rejected the state SLP. But despite the interim order of this Honorable Court, now they have passed an order stopping me from carrying on crushing activities. Now this crushing activity, my respectful submission, my lord, will not in any manner affect anybody, my lord.
That committee will decide.
My lord, committee is, my lord, committee, my respectful submission, my lord, they have no jurisdiction to decide. It is only the state government, my lord, under the KMMC rules, it can decide the matter. Till today, my respect, my lord, they ordered for your lordship, they undertook, my lord, they will undertake experimental blasting. My lord, for the last several years, my lord, experimental blasting is not done. After your lordship's order, my lord, they started experimental blasting. Some 15 to 20 people objected, they stopped it. Now the government advocate has filed a memo stating that, my lord,
No, I am filing a memo. Okay. I am filing a memo. Lord, now the date for experimental blasting was fixed from 24/6/2024 to 6/7/2024. There are two stages, Lord. One is for digging the holes, and experimental blast will be conducted from 3/7/2024 to 6/7/2020. Quotas. States in the letter of the senior geologist written to the executive engineer.
Let the government advocate, my lord, will agree with me to this extent, my lord, that we are not using any blasting materials. Your lordship passed the order because that was a case of the quarry lease conducting quarrying operations using the blasting materials.
I apologize, Lord, there's no translation.
Not translated.
Not one second.
What does it say?
Last may kindly peruse the last page, page number 3, wherein dates are mentioned. For digging hole, that is 24/6/2024 to 2/7/2024. For experimental blasting, 3/7/24 to 6/7/24.
Experimental blasting.
Yes, it will be conducted by expert body called CSIR, Dhanabad.
And that will be, the detail will be submitted to the committee.
Yes.
So it is at the instance of committee. This experimental blasting is at the instance of the committee, or?
That was what I wanted
Your
to,
lordship's order.
that was what I wanted to submit, my lords. This letter is addressed from the geologist, my lords, to the executive engineer of the Kaveri Neeravari Nigama Limited. But it does not mark a copy to the committee. Now, this engineer is ex officio a member of the committee. But my learned friend may clarify whether this has been done at the instance of the committee or whether the committee is in the know of this exercise.
Lord, the purpose of this honorable court on the last occasion directed to conduct.
Your submission in any case will not change the fate of the petition.
It will not change the fate of the
It is same.
petition. Yes.
As those.
This case which
Lord, this will aid. this will aid the decision-making process.
Like this, the learned amicus really Manchamma Devi, my lord, that was with regard to the quarrying, my lord. It is not the crusher unit, my lord. So the contention advance, I was there, my lord, where the contention was, my lord, it was about 19.5 or 20 kilometers, my lord.
So
that
you
was the
want
contention.
yourself to go before the committee? Or
My lord,
you
I do not require to go to the committee because the reason is, my lord,
But
I am
we-
not conducting any the blasting activities or quarrying activities, my lord. Your lordship's order, now what is sought to be made in this experimental blasting is those who are conducting quarrying operations, my lord,
We
not
are-
those who are conducting crushing operations. my lord.
we are not able to devote any further time in arguments and deliberation. We have taken our judgment. This is to go before the committee. The option is to either you go yourself or we'll pass the order in the line of this.
Like this matter, my lord, with due respect, I submit, my
Yes.
lord.
I appeal not, in this matter, I filed an application for implement. And also, my lord, an application, my lord, for clarification. The matter had arises like this, my lord. The order with the interim order which this honorable court passed in this case was arising in a case relating to blasting. That interim order, my lord, was followed in another case by your lordships. In a matter, my lord, which did not involve blasting also, but quarrying. That order was followed in my case, and a similar order was made in my case to say I must also await the decision of the committee. That order was challenged before the Honorable Supreme Court. The Honorable Supreme Court, my lord, granted leave to us to approach your lordships in this petition. Because we pointed out to the Honorable Supreme Court that the order which has been followed is not applicable to me. So the lordship said, you better seek clarification in this order. There's such an order made, my lord, in my case. So I have filed an application for clarification to say that cases which involve no blasting, in my case, my lord, it's a quarry where the quarrying lease says no blasting. I've not been doing any blasting work. I'm 15.5 kilometers away. So I am outside.
Your case is same as.
He is, my lord, stone crusher. He's, my lord, taking boulders or stones and he's crushing. His case is he's not doing blasting. I don't know about that, but my case, the lease.
In your case, no blasting is involved.
No, the lease, no blasting is involved, and the lease granted to me puts a condition to say you shall not use any blasting. So I have not been using any blasting, not from the time I've been not mining for more than 10 years now.
This category of cases.
Lord, so far as crusher is concerned, Lord, the raw material which is supplied to the crusher is from the quarry, nearby quarry.
No, sorry.
What? Lord, no, that's not correct. Lord, the raw material which is boulders.
Why you have filed the application in this matter instead of independent proceedings?
Lord, my difficulty is this, my lord. They gave me a letter to say in view of the order of the Honorable High Court, you cannot now continue any activity. Yes.
This matter.
Yes.
Therefore you go before.
So, my lord, yes, then, my lord, I filed a writ petition before your lordships. And the Honorable Court, my lord, then said that in similar cases, an order has been made and your lordships followed that order and said, I should also await committee. When I went before the Honorable Supreme.
The order, my lords, passed by your lordships in the other writ petition is at page 7 of the application for impleading filed by my learned friend. My lords were pleased at para 5.
Where is impleading?
It's an impleading application, my lord, is filed by me.
Number
6 in WP 19835. A list agila, it's not listed, my lord. I'm told the file is come before your lordship.
Not
6.
Not listed.
It's not on board today, not listed in the cause list.
Number 2 and 3 is of also similar nature, wherein I am only extracting this.
But you are selling in the wrong board because we are not undertaking.
I have filed an impleading application therefore.
But I may point out.
I have been directed to come before this honorable forum by the Honorable Supreme Court, my lord. Because when the lordships noticed that my case is different.
Ganesh Kanal.
This is one CG Kumar.
DG Kumar.
In the proposed respondent is one D Vasanta, madam, my lord. Please see page 7. The same party, my lords, had filed the earlier writ petition, where the prayer your lordships get at page 8. to direct the respondents to permit the petitioner to continue with its quarrying activities as is being carried on without blasting in the area mentioned so and so. Your lordships were pleased at para 5, my lords, to reject the writ petition in light of my lord's order passed in the connected matter which I had just furnished to your lordships. Permitting, my lords, the petitioner to approach the statutory committee. The SLP against this order, my lords, at page 13 was withdrawn with liberty to approach your lordships. Page 13 is the order of the Honorable Supreme Court. And in the I hope your lordships have page 13, my lords, of the IA.
The present petition is by one C.G. Kumar.
Yes, my lords. It is in this petition that your lordships have made the principal orders prohibiting, my lords, mining and allied activities. Now, in connected petitions, my lords, the question has come up whether stone crushing, quarrying is an allied activity or not. Your lordships have been pleased to consistently relegate all those petitioners to go before the committee and, my lords, point out whether the activity carried out by them poses a hazard, my lords, to the KRS dam or not. And in this main petition, my lords have passed an order on 5/3/2024, disposing of the applications that were filed for impleading and clarification in the same lines, my lords, asking the impleading applicants to approach the committee.
So you withdrawn before the Supreme Court and come here.
They went to the Supreme Court and withdrew the SLP with liberty, my lords.
Now that aspect also may be finally decided by the committee.
By the
whether
committee.
Blasting is necessary. or
Quite
not.
so, quite so.
No, my lord, my case, my lord, I'm afraid, my lord, my
How do
learned
we-
friend is
we are
not
not-
correct, my lord. My learned friend, my lord, as amicus, my lord, is, my lord, I think, raising issues which don't arise in my case. He's not amicus in my case.
He
My lord,
was
in
not-
my case, my lord, my case is very clear, my lord. It's nobody's case that I am doing blasting. If your lordship sees the first interim order, my lord, granted by your lordships, entire order is based on the premise that there is blasting. Kindly, my lord, take the interim order dated 8/1/24. In paragraph number 5, the main argument was that these units are carrying on mining activity using blasting technique, which is causing a lot of vibrations and is going to affect the dam. In para 5, my lord, may I read, no? CSIR, CM Simfer was requested to conduct scientific study. So-and-so YD letter dated so-and-so submitted a detailed planning for the experimental blasting and monitoring ground vibrations to investigate the safety of KR Sagar Dam due to blasting activities. And at the relevant time, the entire world was facing after effect of COVID-19 pandemic. It was submitted that the study would be carried out as soon as the condition of COVID-19 was improved, the situation would permit the field study. That is the first point. Then please go to next point, para 6. So-and-so also invited our attention to the opinion expressed by the Dam Safety Review Panel, which reads as follows. All mining activity in a radius of 25 kilometers around the dam site be banned until expert opinion is obtained through so-and-so. After proper ground test, evolved specification for safe blasting. In consultation with IRM, who have a record of proven expertise on this project, the comprehensive study being undertaken by so-and-so as part of the investigation as allowed to be carried out to obtain the recommendation regulation of blasting activities taking place. That was the whole basis of the case, my lord, which
The Honorable Court, my lord, thought it was important. Then para 8 again, my lord. Third line of para 8. So learned government advocate on instructions submitted that at least 6 months would be required to conduct scientific study for ascertaining potential damage to dam by mining activities involving blasting.
No, that is right, but the factum that your activity doesn't involve blasting is an admitted fact.
No, that is a matter, my lord, till today, my lord. I've been mining, my lord, from 2016.
Yes, then we can proceed to pass the order.
My learned friend may please assert.
But when they are silent, we don't know.
No, my lord, my learned friend may take instructions, my lord. The mining lease, the quarrying lease.
The order dated 5/3/2024, passed in
Lord, in the statement of objections filed by
Better
the,
take instruction in whether in case of the need of the council, the blasting is involved. Or
my lord, in the statement of objections filed, they admit that it was not blasting.
Even in case of crushers, no blasting is involved. In case of crusher, there is no blasting involved. In case of polishing unit, there is no blasting involved. The point is this, my lord, the raw material, the
So there must be some
mineral which is
no, some term of reference must be there with the committee. What is the term of reference? Terms of reference.
Para 9 of your lordship's order, my lords.
There are 9 of the order of that order.
Yes,
Per order.
lordships.
Not on facts, my lord. In the statement of objections filed by the state to my writ petition, they say that we are not using blasting, my lord. This is an admission on oath before this honorable court in the objection statement.
no, I am making.
It's not, they are not silent. This is what they say, my lord. Petitioner was carrying out, adopting operations, non-blasting method without using explosives to extract black granite. Non-blasting methods includes usage of wire saws and rock cracking powder. This is the stand taken by them in the objections to my writ petition.
Lords, may I show your lordships para 9, lords, to assist your lordships?
There are 9 of which order?
Order dated, my lords, 8/1/2024.
Yes, 8/120. Yes.
Mr. So-and-so was justified in submitting that the material placed before this court indicates that the statutory committee conducted only one meeting in the year 23, whereas the statutory requirement.
Yes.
That part is regarding, my lords, holding the statutory meetings at least twice a year. Then, my lords, in the backdrop of what is discussed above, we at this stage of the proceedings issue the following direction. All mining licenses, leases comprising any area, whether in private land, government land, or otherwise, that lie within a radius of 20 kilometers from the periphery of KRS Dam are hereby kept under suspended animation. And as a consequence, no mining or allied activities shall be carried on or continued by any person or agency till after a decision is taken by the statutory committee constituted under the provisions of the Dam Safety Act on the basis of report of study and research as discussed above. The prohibition of mining or allied activity as directed in the preceding paragraph shall apply to all cases of mining, notwithstanding that such activity is being carried on under the orders of this court or the jurisdictional authority that were made prior to the date on which the Dam Safety Act came into force, that is 30/12/21. The authorities may, my lords, enforce, etc., and give wide publicity. Now, this phrase, my lords, mining or allied activities, your lordships considered in the order in the connected matter as to whether, my lords, maybe there is no blasting, but if there is some vibration or other adverse effect upon the dam, then your lordships felt that it is for the expert committee to consider and pass orders. And my lords have consistently followed that in respect of crushers, quarrying units, though not carrying on mining activities.
What is your unit, crusher?
I am not a crusher, my lord. I am a mining, I am carrying on extraction of ore. And that is without blasting. That's what is admitted position. My lord, your lordships may please not interpret this order in the manner in which learned amicus is saying, Lord. Any order of the honorable court, my lord, is not to be read as Euclid's theorems. They have to be read in the context of the facts that come before the honorable court. The fact that came before your lordships, my lord, was here is
so
blasting.
We are not aware what is the scope and ambit of allied activity. Today.
Yes, that was not discussed. It was not subject matter. There was no discussion.
Committee seized of that aspect, that very aspect.
Probably
that is the only moot aspect of the committee.
No, my lord, may I respectfully submit this, my lord. When facts relating to one issue is before your lordships, my lord. If your lordships have used the expression allied activities, now please consider, my lord, what effect it has had on other people who, against whom there was no complaint. The government also says in my case that I'm not using blasting and there is a mining lease in my favor. I have machinery, equipment.
Yes. All.
Everything has come to a stop now. My lord. Thousands of people, my lord, are on the street now. Lakhs and crores of rupees machinery, my lord, is lying unused. We have been mining, my lord, for more than 15 years. We have active mining leases. We have to pay dead rent.
All the controversy will put an end by the anticipated experimental blasting report. That is contemplated from 24th July to 24th June to 6th July 2024. Now that will indicate what are all the activities impact the dam. The report which is the blasting, experimental blasting, which is contemplated by an expert committee called CSIR, Dhanabad. They are going to conduct experimental blasting from the stated dates, from June to July.
Now, this experimental blasting which they're doing is completely irrelevant so far as my learned
That
friend
will
and me are
indicate the
concerned.
impact of the
Because we
mining
are not doing
activities on the
blasting.
dam. On the dam. Yes, Lord.
Affidavits.
We have not filed an affidavit. Please.
No, prohibition is only
Lord,
by
so
virtue
far
of
as
your order.
prohibition is concerned, it is for the expert body, expert dam safety organization, they have to say.
Lord, the government did not take any action. It is by virtue of the honorable court's order. Not the government, my lord, did not wake up and said this is affecting. But your lordships, my lord, said that it may affect. Therefore, to the extent of blasting, my lord, let this order be confined to the extent of blasting, my lord. Today, it is nobody's case that what we are doing is affecting them. I can understand if government had done some study. No, crushers are also affecting.
We are doing a study.
Others, my lord, they didn't do anything. That's not their case also, my lord.
That was precisely my lord's observation. My friends may not mind, my lords, I'm only assisting your lordships. Para 5 of your lordship's order in the connected writ petition. That is, my lords, in Manchama Devi stone crushers case. Please see para 5. This was what weighed with your lordships, my lords. I'm in your lordship's hands. Please see para 5. It was undisputedly stated before the court that the committee is seized of the very subject matter and the related aspects. It was further stated that the committee has been addressing the issue as to whether, in addition to the mining and crushing activities, which activities could be said to be falling under the category of allied activities, which would cause and would have a tendency of causing danger to the dam site and safety of the dam. Very good.
But that was nobody's case, my lord. I can understand, my lord, we are in an adversarial situation or in an inquisitorial situation in a PIL. If one party, my lord, if government or any party who came before the court said that stop all allied activities, then Lord, there are transport companies which transport this. That also should be stopped.
I believe not, my lord. Subject to correction, it has not been.
My submission is, my lord, in my case, my lord, kindly pass some order, my lord, as is most appropriate, because in my case, my lord, when I went before the Honorable Supreme Court and I withdrew my SLP, the lordship said you may approach the court in this case. So I have filed this application. Lord, my case, my lord, I may be impleaded, my lord, and some order may be marred on my application, my lord.
Get the 5-3 order.
My lord, in my writ appeal, please.
As your lordships, please.
My lord, my writ petition which went before the Honorable Supreme Court, in that I made two applications. My lord, there were some directions which your lordships had given. I sought for some modification. Could that also be listed on the same day, my lord? It's WP 3339. I'll give the number. 3339 of 24. 3339 of 24. Writ petition. No, my lord, what happened was your lordships disposed of that matter. And in that your lordships gave two directions. One is I can remove what is already mined and the committee should take a decision. So, my lord, I have sought extension of time, my lord, for removal and also to fix a time for the committee to take a decision because they have not taken any decision now. No, not today, my lord. It can come up along with this. It's independent, no doubt, my lord, but it arises out of this in the sense that this application I filed in the current writ petition today arises from a final order made in that case. Please.
Obliged.
Come on 20th, no? Same date. Grateful, obliged.
You want to list?
For listing, my lords, tomorrow.
Tomorrow? Why?
Tomorrow. My lords, the urgency is that my lords, husband and wife, my lords, at the time of dissolution of their marriage, my lords had entered into a memorandum of settlement. Now, my lords, the husband has violated the terms and my lord, he has taken the children to Chennai. The schools have started from today, my lords. The children are missing the school. Tomorrow, my lord, that is the urgency, my lords.
Number 48
Not
and
tomorrow,
65.
10th.
Please, grateful.
Number 43,
48 and 65, IO need to be extended. 48 and 65, IO need, interim order need to be extended.
For?
Serial number 48 and 65.
It will be all.
Serial number 40, serial number 46, my lords. It's an
All orders which are
my
interim.
lords, it's an election matter, my lords. Kindly, it may be taken up tomorrow, my lords. The only issue is administrator appointed on 27/20/2023.
Tomorrow not possible.
Day after tomorrow, my lords.
Day after tomorrow also not possible.
My lords,
13th of June.
my lords on top of,
Lordship,
may I
serial number
request one more?
43,
May I- top of the list, my lords. It's a
Serial number 43.
the election matter, 27/10/2023, administrator was appointed. So no election is conducted, my lords.
13th of June.
Serial number 43, your lordship. The order was passed almost about 3 months back for transpose. And still they are not compliant with the office objection or the, let's say, amendment. Let them carry out the amendments, your lordship. So matter is pending almost for more than 20 years of Paura Karmikas, civic workers. Them carry out and let the matter be posted by next week at least for arguments.
One submission, my lord.
43, your lordships.
Lords, I'm praying that my writ petition may be tagged along with the writ petition at PIL and serial number 68, my lord. Only submission, my lord. In fact, the learned single judge had directed that this matter come before my lords in the PI, along with the PIL. By inadvertence, it has not come up today, my lord. So when the matter comes up next time, my matter may also be called up.
Which PI?
Lord, PIL at serial number 68, my lord.
Road.
Along with?
Don't delay road.
My matter has not been listed today, so I'll give the number, my lord. Let it be listed along with it.
Read petition will come here. We don't know unless there is, you show the order, mention
First, memo is ready, my lord. I have a
which memo.
order, my lord. Learned single judge had passed an order directing the pay, my matter to be listed along with the PIL, my lord. I have enclosed the order copy also, my lord.
Which PIL?
PIL at serial number 68, my lord.
Which is PL 27558.
Yes, my lord. It's at serial number 68, my lord.
We'll see on that day.
Serial number 43, your lordships.
Yes.
44, my lord, anytime during the course of this week. Matter had come up last week, owing to the urgency, the matter was listed.
Which one? Today on 44. So what do you want?
Anytime during this week. Anytime during this week, if the matter could be listed.
Anytime during this week. June. Earliest we are giving.
Serial number 42, my lord. Interim order is there, my lord. Kindly
43,
extend the
your
interim
lordship.
order, my lord.
Serial number 43, your lordship. Any day by next week, it will be listed. The matter has been hovering almost for.
Dates will be given now.
Interim order is there, my lord, in serial number 42. Kindly be